Bonjour à tous.
Good afternoon to you all. We've waited a tiny bit for everyone to take their seats. I think we're ready to get started. I'm hugely impressed with your timekeeping. You're all very much on time, and it's very disconcerting for me as a French professor at university. You are all here at 2 o'clock and 1 minute past 2. It's amazing. In any case, I'm feeling slightly giddy about just how punctual you are and how brilliant your timekeeping is. My name is Moderator. I'm a professor in the University of Strasbourg. You have all the information on your documents. I'm going to be introducing you to the members of our panel shortly. But first of all, I'd like to thank very much indeed the organisers of this conference. There are so many of them, but I'd like to send my thanks in particular to Stéphane and Ajahn Choumi, who we've been in touch with regard to the organisation of the debate on the logistical side of things. We're going to be talking today about new routes for legal and judicial information. And to address these fascinating and detailed topics, I have with me Genevieve VANDERSTICHELE, who is the Chamber President of the Ghent Court of Appeal. I have Hannes WESTERMANN, who is a researcher at McGill University in the Montreal Cyberjustice Laboratory. So he has very useful and valuable skills for us. We have Sandrine, ZIENTARA, who's the Chamber President Director of the Department of Documentation, Research and Reports at the French Court of Cassation. And we also have Mr. Tigran, KARAPETYAN, who's the head of the Transversal Challenges and Multilateral Projects Division. That sounds wonderful, doesn't it? And you are here to deal with the implementation of human rights, justice and legal cooperation standards in the Council of Europe. Before I give the floor to our panelists, of course you're waiting to hear from them, but I'm here as a moderator and I need to slightly introduce the topic and set the scene. And I want to give you the view from an old man's point of view, because as students here. Now, when I was a student, we wanted to consult the judgments of the Court of Cassation. In the lesson, we were told the number of the judgment in the official journal, which was in paper at the time, which meant that at the time, if we wanted to find the rulings and judgments, we had to go to the library, we had to find the volume in question of the official journal, and then we needed to leaf through the documents and find the judgment and then take photocopies of it. So it was a very difficult way, a physical way, if you like, of getting hold of the information. You could feel it, the weight of it in your arms when you're carrying it around in the library. And it's quite rare information, certainly with regard to legal and judicial information. Now we have it in abundance, of course, but it was rare at the time. We didn't have access to all the rulings of the Court of Cassation, only judgments that were selected as ones that were worthy of being featuring in the official journal. And there are others that we weren't allowed to access, that was sort of one-off or unique ones. There are ones that are often commented on in periodicals, and they're always a subject of fascination because they're inaccessible. And then we've had the whole system of the introduction of sort of what we call in French dematerialization, paperless, electronic documents. And this term, if you listen to it, is all about what has disappeared rather than what is appearing now. What has disappeared? Well, the materials as such have disappeared. That is the very cumbersome, awkward side of things, things that you have to carry, you have to touch, and all that's disappeared. And then we can suddenly find ourselves in a situation in which you have information on a different scale. We can access not only to all laws, to all regulatory acts that have been passed by the government, all decisions taken on every day. You can consult not only all the judgments of the Court of Cassation on this occasion, but why not judgments of the Court of Appeal, and perhaps one day, which seemed not long ago, all the decisions are taken in the first instance. Now, the first effect of this was to sort of free us up, if you like. But then we are sort of hostage now to a new form of abundance. There's now too much information that we have to deal with. So then we move to digitization. Digitization is something we weren't interested in at the beginning of the process because the material sort of will disappear, but we're interested in it at the end of the process, that the material then is digitized and it can be used and manipulated in inverted commas by machines. And this is the answer to this overabundance of information, that is to get our computers to discover this, if you like, uncharted continent, that is justice and judicial information, to try and make sense of it, to try and come up with statistics and matrices, and to come up with arguments. And once again, in carrying out this sort of exploration in the legal and judicial information, you use sort of quite simple matrices. You want to try and identify trends with regard to awarding of damages, if it's too generous or not generous enough. And now with online of machines, you can start looking at the legal arguments, legal reasoning, which becomes much more sophisticated. But to do this, and this will be the end of my introductory comments, just don't worry, we need to use intermediaries, because if you're on your own, a legal professional, you have to deal with all this information, something you can do with it. You need to be given tools. These tools need to be thought up, and then you need to get hold of them. Now, perhaps you need to buy them. And you'll find these tools from private, innovative sources. Sometimes it can be sort of classic sources used in the past, which have become more modern, or they can be sort of sources such as legal tech. But there have been lots of changes that have occurred since the beginning of the process and the current state of things. Because at the beginning, you would have the Court of Cassation, which would choose which of its judgments were accessible, whereas now in the current state of affairs, we're given everything. Judges no longer decide. They have to communicate all their decisions. Certainly in this French system, it may not be the only system that we can envisage, but and then it's down to other people, private players, if you like, that can help us to have a clearer view. So power and money is affected by this and having an impact, of course, on this particular field. This is what we're going to be talking about. And let's start, first of all, with this round table by hearing about what the opportunities are for open data in justice or judicial decisions. We're going to be hearing an optimistic view of things, and then in a sort of binary setup, as a professor of law in France, you know, of course, that we're always tormented by this. We always have a sort of a pessimistic view and an optimistic view. So we'll be hearing later on from the pessimistic view with regard to the risks, but there will be a third part of the discussions when we'll have discussions with the audience. So let me start then. Let me give the floor to Mrs. Sandrine ZIENTARA, who's going to talk to us about the French system of open data and justice decisions and what the advantages of them are. Thank you very much indeed. Thank you for giving me the floor. And I'd like to, first of all, once again, thank the organisers very much indeed for this very, very rich and impressive conference. There are so many interesting discussions that can be held as a result of this. I'd like to thank you ever so much for this indeed. Let me just renew my thanks. And I'd also like to thank the IODG team. And I've been asked to talk to you, first of all, about the French model. Now, if you go through the whole, read the term of French model, I'm going to talk to you about the French system. It's not a model as such. It's not an example that would necessarily be one that can be followed by everyone else. Now, the French model for open data, that is relating to the decisions handed down by the courts, is a model of dissemination, not a selective dissemination model, but an exhaustive dissemination model of decisions. The principle of dissemination open data of all judicial decisions, which will be published, was laid down by a law for a digital republic, which was passed in October 2016. Now, this distribution is involving making it free of charge in electronic form in a format that can be easily reused and exploited by an automated processing system. Now, of course, subject to advertising rules, this concerns all decisions of the courts. Now, regardless of the relevance of the legal scope, regardless of whether they're reasoned or not, regardless of what they're deciding on, if they're simply deciding on one incident or the actual dispute, regardless of whether they deal with a very specific dispute or a more general one, it's all decisions that are handed down by courts are published and can be available in electronic form. This, I think, is quite a unique model in Europe. I certainly think that most countries have plumped for a selective dissemination model, not an exhaustive dissemination model for decisions. The Court of Cassation, and more specifically, the documentation service for studies and reports that I'm fortunate enough to be the head of, was entrusted with the responsibility, the very difficult responsibility, of disseminating into open data all decisions of the courts. Now, if you look at the number of decisions concerned and the technological stakes, which were huge, and the challenges we had to rise to, it was decided to do this in a gradual way. So since October of 2021, all recent decisions and non-recent decisions, this is a new feature compared to what you were talking to us about, when only published decisions could be accessed, and then published decisions and disseminated decisions. And now, in addition to these, non-recent decisions can also be accessed on the Judi Libre site of the Court of Cassation. All decisions that are handed down by the Court of Appeal in civil, commercial and administrative law can be accessed since April 2022, and in November, or perhaps should I say December 2023 of this year, we will be disseminating all decisions handed down in civil, social and commercial disputes by 9 judicial courts of first instance, among the leading courts in France. This means that we have currently 800,000 decisions that are disseminated through the website, 280,000 concern the Court of Appeal, and 520,000 concern the Court of Cassation. We then, during the course of 2024, need to put into open data all decisions handed down by the trade tribunals and all decisions made by the employment tribunals and by criminal courts as well at the end. If we were able to put into place the decree that set out a timeline for disseminating open data, the theoretical aim is for all decisions to be disseminated by the end of 2025. We'll be talking about 4 million decisions. Now, what is the aim of this model? It's a colossal model, of course. Well, I think it's not only aimed at having a digital definition of justice, or it's not about strengthening access to rights or to the law. Since 2002 in France, all recent decisions handed down by the Court of Cassation were already accessible via Legifrance, and they were available free of charge, as well as part of the decisions handed down by the Court of Appeal, which were of particular interest or relevance. France was therefore, in 2016, when this law was introduced for a digital republic, was already quite far ahead of the game when it came to access to case law. The stakes or challenges related to this exhaustive dissemination model are, I think, slightly different in nature. They are, of course, it's all about democracy, economics, and geometrics. Now, with regard to the democracy side of things, I'm thinking of the transparency of justice. That is to look at how courts are handing down judgments. The citizen is not having access to the positive law. That's how the law is interpreted by case law and by the Court of Cassation and some courts of appeal. That is access to positive law, which was guaranteed. We're talking not about this, but access to the application of the law in individual situations. And when you can familiarize yourselves with how courts are judging on certain affairs, in particular when they intervene in fields in which their powers of assessment are sovereign. And this is something that can be referred to as concrete case law or jurisprudence. With regard to the second objective, the second purpose, if you like, of this model, well, this is related to debates held in 2016, which were mainly aimed at the development of the market of data and legal tech. The aim that was set was to place at the disposal of private operators these judicial decisions so that this could promote the development of artificial intelligence programs. And last of all, the last objective, I'm referring here to the modernisation of justice and working methods of magistrates and judges. The aim for this in 2016 was to place at the disposal of law practitioners, and in particular magistrates and judges, tools able to analyse case law, tools to help with decisions, to ease their work, and to enable them to free up time for more complex affairs. Moreover, by enlarging this initial objective, open data can be seen as representing for magistrates and judges themselves a tool in which you can become familiar with the case law, which is currently developing on emerging disputes. Each magistrate can rule on a new area of law by being fully aware of the case law of all other courts on this matter. And the Court of Cassation itself will also be in a position to play its unifying and regulatory role on new matters while having an overall and exhaustive vision of case law on how the issue has been dealt with by the judge of first instance. This means it's then possibility, I think, to have a renewed dialogue, a vertical dialogue, if you like, between courts of the first instance and the courts of appeal, between the courts of appeal and the Court of Cassation, in upwards and downwards, and of course a sideways dialogue between courts of the same instance. Thank you very much indeed. We're now going to take advantage of this free information. We're going to give the floor to Mr. Westermann to ask him just what he's done with regard to the judicial information he had at his disposal.
Thank you very much for the invitation to be here and present today. So I want to briefly talk about open judicial data, why I believe it is to be one of the most important data sources, but also how there is this opportunity now of using artificial intelligence to understand this data and do new, very interesting things with this. And so for me, this judicial data is, well, as the President speaker explained very well, it is really the crucial data to understand the legal systems. As you mentioned, the laws, while they give an abstract view of how things should be ruled on, and as do the cases of the higher instance of courts that tell lawyers how laws should be interpreted, they can tell us about how these cases are applied in concrete instances. And here I think especially about questions like open textured legal terms and things like words that are used in the law saying that something has to be reasonable, something has to be frequently late, or so on, but also damages. If a law says that damages can be applied in a certain case, it usually doesn't specify what these damages should be. How much does a person deserve for suffering a certain injury, for example? So to understand these things, you need to go to case law, and the case law really from the first instances, because most decisions don't go to the Supreme Court. So to look at what people can expect normally should they go to court, I think these first instance decisions are very important. And that's very important to increase access to justice, as I will elaborate as well. But also I think they have very important democratic meaning, since in order to understand how laws are actually implemented and actually applied, you need to look at these cases. And this in itself can be crucial to be able to interact with the democratic system and to criticize and to choose who you want to elect based on the actual functioning of the legal system. And there is this huge opportunity today with artificial intelligence to be able to analyze and use this data to an extent that hasn't been possible before. So, of course, even if you do have tens of thousands of decisions, it doesn't mean that you will be able to use these in a way that is useful for individuals. So I want to talk about two examples of projects that I've been working on that use judicial data to enable these new and very interesting use cases. First being the JusticeBot. So the JusticeBot is a legal decision support tool that allows users to go online. The system then asks questions to the user and based on their answers provides them with legal information. And there's something we developed at the Cyberjustice Lab. And we have also published a first version of this, focused on landlord-tenant disputes in Quebec, which you can try out at justicebot.ca. And so the way the system works is that it does not tell the user what they should do, but rather gives them context so that they can better make a decision. And this uses open judicial data in a crucial way by showing the user specifically relevant cases to their situation. So, for example, an example that I often use regarding this is that in Quebec, in order to be able to terminate a lease, one of the requirements is that the rent was paid frequently late. But frequently late, of course, is, as I mentioned before, one of these open textured legal terms. It's not defined what should be understood by frequently late, but here it is necessary to go to court data to see what does this mean in practice. So what we do in the JusticeBot is to, for each of these questions that we ask the user, we also give them examples from previous case law. And we say, look, here are some examples where the judge found that a situation was frequently late. For example, someone was late in paying 12 times over the past 12 months. And here's an example where this wasn't the case. So maybe they were only late in paying 3 times over the past 6 months. And that was not enough to be frequently late. And likewise, at the end of the parcours, we show the user decisions of outcomes from previous cases. So we tell them, in cases such as yours, here were some outcomes that happened in previous decisions. And all this information is really useful for the user to understand for themselves how strong is my case, what are some similar cases, and what might I expect should I go to court, without telling the user what's going to happen and what they should do. Another brief example is some research that we did together with researchers from the United States and Czechia regarding thematic analysis of court cases. And this research will be published next month at Jurix, but you can find the preprint online today. And it is regarding seeing if large language models are able to find patterns in court cases. So what we did was we built a system that can ingest many court cases and try to identify patterns in these, such as which factual situations were actually treated in the court system. And this, again, has a lot of potential. So these systems, I think, there's this huge opportunity today to be able to use these kind of systems to understand the legal system in a way that maybe hasn't been possible before. We can use the AI to look at huge mass of data and assemble these patterns from that to understand what's happening. But also, it can be used in a way to democratize the legal system by giving people these insights and giving them similar cases and informing them what might happen should they go to court. That can give really hands-on, concrete opportunity. But all of this relies on this open data being available and having these AI systems today that can deal with that.
Merci beaucoup.
Thank you very much. We decided to take our speakers in this order because we have 2 speakers in the panels, because we have 2 speakers who are more optimistic concerning open data and AI, and 2 others who are perhaps a bit more critical, if I dare say. So, advantages, opportunities of open data. I'll give the floor to Mrs. VANDERSTICHELE. Perhaps there are some good things that you can highlight, and in the second part we'll hear the criticism and also the note of caution, also most interesting. Please let me thank the organizers of this extremely enriching and extremely interesting conference. Secondly, I would like to say that I'm a judge at the Court of Appeals of Ghent, but I'm also at the Digital Transformation Office of the Belgian justice system in order to help guide towards the digitalization of the Belgian justice system. So I'm not really spending much time at the appeals court. I'm mostly there with my hat of the digital systems. I've also written a doctoral thesis at the University of Oxford on the role of the judge and how it should change with the help of AI and digital systems. A third comment I'd like to make. I'll be speaking both languages. French and English, because over the last quarter of a century, I've been doing most of my work in English rather than French. So I'll be speaking either one or the other and switching back. Do I see any positive elements in open data? Definitely, but under very strict circumstances. As compared to what I've heard until now, I'm not part of the Luddites. I really do believe that, yes, it can bring positive things with it. Would I, as for myself, suggest that the French system become a model? I don't think so, but we'll come back to that later. Thank you very much. Same question for you. Do you nevertheless have some positive things to say? Any hope you can put into this system? But if it's mostly criticism, well, don't hesitate.
Say that what I have to say is actually a criticism of the use of open data or of digitalizing judicial data, but rather words of caution to keep in mind that use of digital data, especially digital data from the sector of justice, judicial decisions, is ripe with many risks. And unless those risks are fully taken into consideration, use of digital data might actually, in fact, be less beneficial and more damaging. And looking into those risks would be extremely important. So dissemination of legal information through digital means, publication of judicial decisions, should first and foremost be rooted in the clearly defined policy of the state. This is something that we've been able to also see through discussions that we've been having in the last year and a half in one of our projects, the Tigran project, who's also actually co-organizing this conference. The approaches have been rather varying on the way what is published, why it is published, how much is published, because all of these are actually elements that need to be fully considered. But importantly, it's clear that there needs to be a clear policy that is understandable, and that policy must be linked to the needs of justice first and foremost. So open data just for the sake of open data might not be the best solution for justice. There must be judicial or reasons in the justice system for the open data for judicial data to be made available. So it has to. We have to look at what concrete problems we are going to solve. And the examples that were voiced here by previous speakers, they clearly demonstrate some of the problems that the publication of judicial decisions was called to solve. And while the access of or ease of access to judicial data is extremely important, it may not be the only defining factor for deciding that, yes, we want to put everything out there. So there should be also considerations related to personal data protection, protecting against misuse of depersonalized information, because even depersonalized information, especially judicial information, can actually be misused. Risks of profiling, etc., which have in fact materialized in some of the jurisdictions which have published judicial data. Equity of such access, we're saying that the access becomes it becomes more accessible, but does it really become more accessible? And is this way of access more accessible than the other ways that existed before? Also, there are other rights which are not necessarily only related to right to privacy, which could be involved, right to be forgotten, correction of wrong information that is out there. And here I must say that legal tradition of a country also matters a lot in finding the solutions. So, for example, common law systems will definitely be looking at solutions which might be different to solutions that are being used by countries with more codified systems of law. And then what's also important is what happens to that data once it's out there. How is it used? Who is using it? Do you need to regulate that? How do you regulate that? All these are questions that must be answered when designing the policy for putting the data, the judicial data out there. So while there is actually a great deal of benefit to having that data out there, and that does allow for a lot of statistics, a lot of interesting new solutions that help lawyers and judges and other legal professionals to do their job. It's important to make sure that when it's put there, we know exactly why we're putting there, and the way in which we put the data out there is in line with the measures we put in place to protect from any misuse of those systems. Thank you.
Merci beaucoup.
Thank you very much. You see that I wasn't exaggerating when I asked you to find advantages. There was a very nuanced answer, and you were immediately cautious. But, of course, that's quite understandable. There are two different schools of thought, I would say. We're not necessarily reassured to find out that France is unique in Europe and also in the world, unless I'm mistaken, because we're alone. We're alone. What does that mean? Does it mean that we're avant-garde, we're pioneers, or does it mean we're wrong? We don't know. So open data, that's a very generous concept. Is it the only possible way to go? Because you're authorizing a use, but you haven't yet found out what use that could be. If you're enabling each and every use, you're then in a situation where you have to trust those you're giving access to, trust that they will make good use of it. Innovating use, pioneering use, we've seen that with the internet. Because we speak of net neutrality or neutrality of networks. That means that the network operator has to authorize each and every type of information through the pipelines because you don't know who will use what. Video on demand, at the time, we would never have guessed that that would exist. Voice over IP, video conferencing, video games at a massive scale. That was absolutely unforeseeable. So obviously, you're trying to reason by guessing what finality might exist at the end of the day, and you don't only want to give access to data if you know how they're going to be used. Well, that was my personal point of view, but now I will give the floor back to Mrs. VANDERSTICHELE in order to hear your vision. Your vision is that of open data with different levels of access according to who is being given access to what. Different approach from the French approach, definitely. Yes, I think that at the outset it's very important, as Mr. Netter and Mrs. ZIENTARA referred to, what's going on with digitalization is not only evolution, it's revolution. It's epistemological.
Et donc, la façon...
So the way we're creating law, creating information in general, and here it's access to legal information. This new way of access is totally changing because of digitalization, and we have to be conscious of that aspect of things. For instance, in the 12th century, proof was putting your hand in the fire. Well, now, of course, nobody will ask you during a trial, well, are you ready to put your hand in the fire and say it's true? And I think it's the same type of change as from the 12th century to today, how law is being applied and how it's being acceded to. It's a total change. Legal search, as was said by Mr. Westermann. Nobody goes to the library anymore to see a file. Nobody goes look in an old book what could possibly have been the position of the Cassation Court in the recent years. So really it's an epistemological revolution. Concerning open data, if you put everything open to everybody. You'll have at least 3 groups of major risks. And I'm not quite convinced that it will be the same advantage for companies. Won't there be more risks for them than opportunities? There's a major risk for the rule of law, for instance. How do we want to create this judicial information? You have to look at the software cycle.
Donc, la sélection.
It's a selection of data, but it's also data cleaning. And then there are requirements and specifications, a choice of statistical methods.
Of the outcome. And then the application of the outcome, every single step requires a legal interpretation. And it requires to incorporate values. So far, let's say, by and large, since the end of the 18th century, everybody agreed that that should be done by a court system, and that court system is independent from the executive, from the legislature. If you now all of a sudden have an executive power together with a commercial power, making all those small decisions, and you can use the technology if you want to, for every step in the decision-making of a judge. So if you delegate all those small decisions and big decisions to a private company or to the executive power together, because in Belgium it has been asked that the software developers of the Ministry of Justice will get involved and will develop the systems that the judges will use. That is a delegation to the executive power. So where is the independence of your judiciary? I would like somebody who can explain me this. Where has the independence? So the monopoly of decision-making is broken, of judicial decision-making. It is no longer existent. It is shared with the executive and with private companies. And I would be happy to share my monopoly if it would be done in a democratic way. And that is my second argument. I am not sure that putting your data and then hence allowing everybody to develop tools with them, because there is that second step that is allowed with opening the data, that is actually enhancing access to justice, and that is actually favoring your democracy. I think to the contrary, it will favor big law firms, legal tech companies, but I'm not sure that individuals who are confronted with millions of decisions will understand better what their rights and obligations are. So you need a new intermediary. And linked with the democratic aspect and with the état de droit, the rule of law aspect, so far an interpretation of the law was done in an authoritative way by the courts. And I don't see why digital technologies should take that authoritative interpretation of the law, take that away from the courts, and certainly not transfer it to private players and the executive power. Again, if somebody can explain me a system where we could use it to enhance democratic participation, I'm all ears. I've been thinking about this for many months now, and I can't come up with a good, solid, valid system. So I'd be very interested if somebody, maybe Linda Mulcahy and Anne have ideas, maybe Orna has ideas, I don't know. I don't want to point to you, but I know you have very interesting work, and that's why I think about you, about democratization of access to justice and of the court system. So there's a third argument next to the rule of law, the democratic aspect. There's a huge concern of safety, which is very little discussed. And that is, if you open all your data, it's like in Belgium, all data of related to insolvency cases, so with businesses and with private persons, they're all privatized. We have a parallel private greffe, administrative system, back office of the court is completely privatized, and it has been repeatedly said that they sell the data to an American company. I've never seen the contract, but that's what's been said. This opens up information about a state, about the economic tissue, the fiber, the very core of the Belgian system, for maybe very good applications and very interesting applications that could enhance a lot, but you also open them up for people and states and gangs with completely different interests, and maybe interests that are not enhancing democracy or the rule of law. So these are my three arguments. So what do I propose instead? I think I proposed a three-tiered system. The tier one is that les avocats, so the lawyers of the parties, should take their responsibility. And the first transparency lies with the parties and their lawyers. If a judge is misbehaving in a case, it is the duty of the avocat, the lawyer, to call out the problem, to appeal, and to talk to the bar, to talk to chief justices. So there are other systems in place, and the first tier is the lawyers themselves. The second tier in the system is that you make available all data for very specific purposes to researchers, maybe to journalists, maybe to companies, that can be discussed, but you make them available under a system of license for specific analysis, for specific dissemination in favor of your democracy, the rule of law, the public. And you have somewhere in an office, I don't know, in the Supreme Court, in a court of appeal, a computer available for the researchers of whoever has the license can come and make on that computer, without scraping, without taking it home, an analysis. And what is the third tier? I think the authoritative interpretation remains with the courts and in the court system. So I think the courts, instead of throwing out, because, yeah, and I'll make the point first and then I'll say why. I think the courts should make abstracts of the decisions available to the wider public. What is an abstract? You state the facts, the legal question, the arguments of both parties, the answer to the legal question, and the concrete outcome. And you can abstract that. It should address privacy problems at the same time, but with an abstract, you reduce the amount of information and you have a specific, usable answer to a legal problem for the parties and who can search through it. So putting those abstracts out is the responsibility of the courts, and they should be accessible for free. And I think I have already overstepped my time or exceeded my time, so thank you very much.
C'était parfait, merci.
That was perfect, thank you very much. Well, it's difficult to imagine a more clear-cut difference of views when it comes to the use of open data. Now, Mr. KARAPETYAN, in the exchanges we had before this panel, you expressed a number of concerns. You've expressed some today, but you also hinted at good practices that you've identified or that you're trying to identify with your department so as to be able to use responsible open data. Is that something you'd like to share with us?
Well, as I said, part of the discussion and some of the key positive practices that came out of the discussions that we've had recently are, first and foremost, that there's an understanding of the risks, and then there is actually a risk management methods. There also has to be remedies when the risks are realized. So if the data is out there, it's wrong, or it's in the wrong hands, what are the remedies? Do they exist? I mean, is there a way for a person to actually come to somebody and say, I need to fix this? So that's an important one there. Licensing is one of the ways in which was used by some of the states to control the data, to make sure that it doesn't get in the wrong hands. To which extent it's fully effective is another question. I think there could be many opinions on this, because once the data is out there, there's always going to be the question, and you know, where does it go? Where else does it go? But having some sort of rules for that, once you give the data to third parties, would actually be a useful exercise. I don't know if you know, sitting researchers in one room in a court would be the most effective way to explore data with the use of some of the modern technology, but also licensing researchers or giving researchers the data with some strings attached to it could be one of the solutions to make sure. And most importantly, I mean, there should be clarity in what is allowed and what is not allowed. What is allowed to be done to the data that is out there, and what is not allowed to be done to that data. Because once the law is clear on that, then at least you can identify, okay, it's been misused, or it's been used against the legally allowed rules, and then there can be actions taken to stop misuse or the wrong use. I don't know if I fully answered your question. We will try to also at the end of the project, which has not yet ended, we will try to also come to a more generalized summary of some of the practices that would then be eventually available. Thank you.
Merci beaucoup. Un aspect.
Thank you very much. There's something we might want to come back to when it comes to exchanges with the audience. I hope that you agree that after the second question we can have a discussion with the room. The question is whether the regulation on privacy of data would apply. You know, there's the question of anonymous data, pseudonymized data. Ms. ZIENTARA, turning to you after what you've already said. Indeed, in the French model, there was an awareness of the hazards and a will to act responsibly, trying to be generous with the access to data, but responsible at the same time. But is there anything else that you wanted to react to in terms of what might be perceived as negative criticism of what's done in France? Thank you very much for rewording the question as you have. Initially, I was very much willing to respond to Madame VANDERSTICHELE. Now, perhaps I need to act as a defense lawyer at this point. It's not an easy role, and there would be so much to say. But I would like to say two things. First of all, when it comes to the critical comments you've made in respect of the rule of law. Now, the public interest might not be self-evident at first glance. You have the feeling that the law is a matter for specialists, for lawyers, and what point is there in giving access to the general public? Give them access to all these decisions. Well, I'd just like to make two comments on this and mention some examples. Tomorrow, the final decisions handed down by criminal courts are going to be made accessible in open data, although names will be anonymized. Now, there is a discussion at the moment in France when it comes to the leniency of judges in criminal matters. So it is interesting to look at all of those decisions and the sentences handed down and the statement of reasons given the gravity of the fact or the personality of the perpetrators, and then carry out comprehensive studies to try and better understand these issues that often give rise to a rather irrational debate, at least in France. Now, another example which might be even more telling, that is discrimination. In France, we were discussing this over lunch, there are very few criminal convictions for discrimination. Now, take a journalist, somebody who's not a specialist of the law, and that journalist might take all the decisions handed down by courts about discrimination to try and understand in what cases the accused might have been sentenced or not, etc. And then there might be press articles written or discussions about this on social media. This journalist might say all sorts of silly things, but then it'll also be up to the researchers to take this up and include this in the democratic debate with perhaps a more in-depth analysis of all of this. I think these are two examples that go to show that placing these decisions in open data, these court decisions, can contribute to democracy, and I think it's something that's far from threatening the rule of law. Coming to your second question, that is leaving it up to judges to interpret the law and not leave it up to the executive power to step in here. And this is all of course, about protecting the rule of law. Now, when it comes to the situation in France, I'd like to make 2 points. First of all, for this reason, it was decided that it would be the Court of Cassation, our Supreme Court, to take the responsibility of placing judicial decisions in open data. And at the Court of Cassation, we have an innovation laboratory, which is not nearly as performant as the Cyberjustice Laboratory in Montreal, but it does try to work with AI tools in order to create decision-making tools which are not created by the executive power and which would make it possible to keep control over the interpretation of the law, which should remain within the power of judges, and then this would also take place in full compliance with the role of the judge. Therefore, it would always be possible for a judge to stray from a certain average if this is justified for specific reasons. As I was saying earlier on, one of the points is also to create a dialogue between judges. And by analysing all of this data, to make it possible for the Court of Cassation to be fully aware of what's decided at lower levels of jurisdiction, therefore to have a good overview of contentious proceedings. When the Court of Cassation has to deal with a brand new question today, it doesn't know how this sort of thing would be addressed by other courts. Now, in this case, with all of this knowledge, the Court of Cassation would have a good idea of other judicial decisions in the same area and also would be aware of peripheral issues that might affect their decision so that they can respond to the question of law put to them. And I think this will certainly contribute to better quality justice, a more effective justice, and a more effective justice in particular in terms of equal treatment of citizens, because the court can come up with replies at its level, the level of the Supreme Court, which will be applied equally by all first instance courts, which can contribute to equal treatment of litigants. I would now like to come to the point I really wanted to make. One of the risks, of course, with the placing in open data of a huge mass of decisions is the risk of a lack of distinction, a lack of discrimination when it needs to take place, and a risk that the Court of Cassation would no longer be playing its role to unify law. There would be this risk to have difficulty in defining case law, and of course this is a risk that we had anticipated on, maybe a bit late in the day. I'm answering you, Tigran, here. What I've just announced is going to be put into place in January, in fact. At the same time, we'll be placing in open data all the decisions from 9 courts of justice. So in January of next year, we'll be launching a process to rank in terms of hierarchy the decisions handed down by trial judges to avoid this lack of distinctions, if you like. And in order to launch this ranking process, we're going to rely on a network of reference persons in courts and appellate courts. And we, the Court of Cassation, will be asking them to point out to us any decisions which have particular legal interest on the basis of criteria which will have been predetermined by magistrates working within a mission together with professors, academics. These criteria can be substantial or formal. Among the formal criteria, for example, a decision which refers back to the European Court of Justice or a constitutional point of law. And among the substantive criteria calling for a more refined analysis, there would be, for example, a decision which would involve an examination of constitutionality, or a decision which would concern a major public interest question, or a new issue which would not have been addressed hitherto by the Court of Cassation. This ranking in terms of hierarchy would take place at the level of the court handing down the decision. When that decision is made public in open data, then it would also, the court would have to point out that it involves a particular public interest question. And this would also involve working with the academics who analyze the case law of the appellate courts near their university. Their point of view will also be interesting. And this means that when the magistrates, thanks to the academics, can become aware of decisions they hadn't necessarily identified as worthy of interest, to do so. And with the Juridique Libre search engine of the Court of Cassation, it'll be possible to look only for decisions presenting a specific legal interest, or if you're doing a search by keyword, will have a list of decisions of the Court of Cassation according to those keywords, and different types of searches will be possible. Just one word very briefly to address the second risk that we had identified. I see. Well, I just wanted to mention it. Perhaps we can revert to it later on, and you in fact touched upon it yourself. Everything to do with pseudonymization of decisions to cut down on the risks of infringement on privacy. Thank you very much. I'm sorry, I'm a very bad moderator. I'm so happy to hear people. I don't interrupt them, and then time passes. I'm very sorry. It was very useful indeed. I'll try and synthesize this in one word. Yes, you can re-involve judges and the administration and the public sector downstream, and that might be a useful point to bear in mind. It wouldn't be exclusively up to the private sector. Not that we're mistrustful of the private sector at all, but the idea that there would be a review on the part of academics and the administration, that would be a good idea. Perhaps we can listen to Ms. ZIENTARA at this point. Or Mr. Westermann, I'm sorry.
Large language models and the risks that the training of large language models with judicial data might impose. And I think this might be a risk maybe of expectation more than a fact itself. So the risk, of course, being that large language models trained on judicial data, and it is very likely that they are today, because judicial data is great, it is very structured, it is multilingual, it is very clean. They become very good at using legal terms and giving legal information. But to understand what might be a risk, we have to come back to what we heard earlier this morning, but in the presentation by Alexi Grindbaum, what these models are actually doing. And a risk here is that these models, of course, don't really understand what they're saying. They simply find the next word in a sequence. And they're very good at acting like they understand, but they might not necessarily do that. And sometimes that is enough. For certain use cases, I think that doesn't matter. The acting is close enough to the truth that it is all right, but sometimes it might not be accurate. And this becomes an issue if people expect these models to be very smart, to be trained on judicial data, and ask them a legal question, expecting this answer to be accurate and give them legal advice. They might be given an answer that is confidently wrong, and based on that do harmful mistakes. Of course, the creators of these models are very aware of this. So if you speak to ChatGPT, for example, you ask it a legal question, it will often say, I'm sorry, I'm a language model, I'm not able to answer this question. And in fact, the terms of use of the OpenAI API specifically says that giving legal advice using these models is excluded, is not allowed. But still, there may be situations where individuals ask these questions, and we did some experiments where we asked the models questions, and we asked the same question to JusticeBot and compared the answers. And while, of course, they're very easy to use and very natural, these models are also sometimes hallucinating and might give responses that aren't accurate. So I want to briefly touch on some solutions to this. How can we address this? The first, of course, being education. Well, understanding what these models are and what they do is really important in being able to use them effectively. And in the end, I think they are a tool, an incredibly powerful tool. It is so impressive what they can do, but it's also important to understand that they cannot do everything, and there are risks associated with them. And this can really be incorporated into the approach used as well. So I mentioned before the JusticeBot that we use to provide legal information. And this approach is very different because it is essentially an expert system. So it is deterministic, and someone can verify what this model, what the system will say at every stage. So a lawyer or even a court can look over these pathways and say, yeah, this makes sense, or this interpretation is not good, and correct them. And they will be sure that the user only sees what they expect them to see, which is very different from large language models. But there is the potential of combining these two together. And there are ways of, for example, so what we tried is to use the models to build a draft pathway that can then go to a lawyer that can verify and make sure that it's accurate. They might summarize decisions, or what they also might do is to suggest to the user which pathway they may want to explore. So it can read something that the user says and say, okay, based on this, we think you may be interested in this pathway. Take a look at this pathway and go through this verified information to see whether you have these legal rights. Again, entering into this deterministic path of the system. So, and another way of combining it is we built an experimental platform called the LL Mediator that uses large language models to support mediation. And here the model suggests, it reads messages by users and suggests to the mediator what they may want to say. So it gives them the possibility, here's an intervention, you can either send this, the mediator, or you can modify it and say what you want or completely change it. So in both of these instances, the models aren't used in a way to directly interface with the layperson user. Instead, they are given as an intermediary step to an expert user that is able to verify the content and to make sure that it's accurate. But in doing so already, there's a lot of gains to be had in terms of productivity and interests. There's one larger point I want to raise that always comes up with these questions, because these models are going to get better and better, and at some point they might give information that is mostly accurate. And there a big question is, what is acceptable in terms of accuracy? How often do they have to be correct versus incorrect for this to be an acceptable use of the system? And how are the outcomes of users affected by receiving information that is not fully accurate compared to users that have no information? Because that is often the alternative, that people who are outside of the system, who don't have access to lawyers, don't have any information. And it's an important question, I think, what this balance is between wanting to help people, on the other hand, avoiding the risks of these systems being harmful. So I think the voices in this room and like understanding these fears and these issues and how the models work with that will be really crucial to build this in a way that is responsible and safe, but can also harness these amazing opportunities of these models.
Merci beaucoup pour cette réponse synthétique.
Many thanks for this very clear, succinct reply. I will now give the floor to the audience. I'm really sorry I wasn't strict enough in moderating this session, but please still feel free to ask a question, and please address your question to one specific member of the panel, because unfortunately we don't have time for 4 different replies to a question. So do you have questions for the panelists? With a microphone, please. From Lexis, chairman of the GF2Z in France. We've been working since a long time in the field of open data. Now, open data, as in the French model, I think is fairly different from what the European Commission calls for, at least on the basis of its texts and instruments. So, personally speaking, I think there are 2 really crucial issues. First of all, to consider that open data replies or meets the needs of everyone, the public at large and professionals. That would be a mistake. As regards legal data from the outset, the editors and publishers and legal tech, generally speaking, would like to have a version of the data in their full integrity, to be able to also provide comments, commentaries, but that request has never been met. Above and beyond that, does the public at large really need access to everything? I'm not convinced. I think that might be a mistaken approach. And then the other issue is the absence of monitoring or supervision. All the data is put out there, and then you think, well, everyone, all companies are quite full of goodwill, and they just want the best for everyone, but that's not necessarily true. And I think it might be a good idea to set up a licensing system which makes it possible to actually monitor the use of legal data, because it's too risky to let the data be available to everyone. Well, you didn't say it, but I think perhaps her question was addressed more to Mrs. ZIENTARA, maybe the lawmaker, who of course is not present. Yes, because we have to keep in mind the separation of powers and safeguards in a state governed by the rule of law. Our legislator decided to provide general access to the public at large. So what can I say to that? But it's quite true that, well, for example, securing anonymity is important, even though you can't always ever rule out the possibility of identifying someone, but we do anonymize a number of things, names, addresses, phone numbers. We don't delete or hide the name of a company, generally speaking, unless it's a small company and it would be too easy to identify the name of the manager or the owner. And we don't do away with the names of professionals, lawyers, judges, registrars. That's the choice that the lawmaker made. Though if there's a particular risk of infringement of the right to privacy, then the names will be concealed. Yes, I also have a question. Sorry, I have a question. Well, I don't want to mispronounce your name, but as to the risks, is there not a risk via open data that there's some filtering of the information that might also be an obstacle to access to justice? I'm not sure my question was clear. Well, that all revolves around the tools that make it possible to settle disputes online, ODR, as we discussed in Workshop 2. There's a system in Canada to settle small claims. settling the disputes thanks to a friendly settlement. But I'd reply, as I did with regard to AI generally. Of course, the data has to be used ethically, reasonably, and the Canadian model is exemplary. Of course, it always has to be possible to turn to a judge, ultimately. Am I allowed to take one last question? The organizers seem to say that it's not such a great idea because we bow before not only the lawmaker but also the sovereignty of the organizers. But so we're only 30 seconds late, and we can always have discussions during the break. And again, my warmest thanks to the panelists for these fascinating exchanges.
Ah, excusez-moi, on me dit que je n'ai pas annoncé les ateliers suivants alors qu'on m'avait demandé expressément de le faire, mais j'ai postulé.
So, I was asked to say a few words regarding the next sessions, but I imagine you can read the program. There'll be workshop 3 that will take place in this room, whereas workshop 4 is the future of hearings virtual. That will take place in G02, workshop 4. Thank you.
Là, il te dit qu'il lit les slides qui suivent, et il passe après quand il est dessus. C'est le fou. Ton sujet, c'est Has the Cyberjustice already arrived? Vous avez bien, mesdames, messieurs,
Ladies and gentlemen, can I suggest we get started with this workshop? And this workshop is all about the far distant or close horizons, the emergence of new legal professionals. Is the arrival of the chat lawyer imminent? Has a cyber notary already arrived? Can blockchain technology be used to digitally enforce court judgments? Don't worry, there are, of course, question marks after each of these sentences. We're coming to the end of the afternoon. It's a Friday, of course. There were 6 at the top table, and now there are only 3. The room is starting to empty slightly because the weekend is just around the corner. So what we're going to do, let me tell you this straight away, we're going to be very strict with regard to the timing because our 2 speakers have trains to catch to get back to Brussels in particular, which means that we need to be very strict about the timing. So I'd like to thank very much indeed the participants, the organisers, our participants who are here in the room and who are following us online. And I'd like to state that since this morning I've been listening very carefully indeed to everything that's been said. I'm listening as a very interested observer who's been passionate about the subject for quite some years, in fact. So I have lots of questions about the whole issue of this digital transformation, which is having an impact on so many different systems, legal systems, judicial systems in particular. And one question we're asking is, what is the value of the law for citizens, for individuals? And there was one time when I tried to put figures to the legal contribution of this with regard to this value chain. Now, I am both a legal and economic background, and we often talk about a considerable value. We're talking about a huge value without going into details. But what about the sort of augmented lawyer? And in the context of digital transformation, how this can contribute more effectively to the value chain in full compliance with the principles of fairness and the rights, people's rights. So the question is all about the impact of this sort of a hybrid system between humans and machines, that is in the legal field, and what we also call the law market. Let's not be afraid of calling it that. Now, there are methods that have been tried and tested with regard to cost and benefits, and we talk a lot about productivity gains, time savings by automizing tasks. This having been said, these approaches reflect a rather restrictive interpretation of law and activities of legal professionals, And let's not forget that we need to give thought to what perception professionals have themselves of this, and it's not always satisfactory. So we know what the challenges, we can see what the challenges are, but I think some of the calculations we're making are the wrong ones, and that seems like a paradox because we're talking about artificial intelligence. It's made all the more complicated because what we also have is what we've been referring to as paradigm shifts. So there have been a number of paradigm shifts, not just the one shift, but several issues that are raised as a result of this. And these are also connected to pick up from the last session, with we're moving from the right interpretation, the judges are interpreting, and they're moving to from a right of interpretation to a right of reply. So it's simply replying to a question, not worrying so much about the interpretation. And this is causing a number of concerns for us, and we're asking questions about this. And one of the first issues we need to look at is what is the operational effectiveness or efficiency of these tools? Now, operational effectiveness in relation to the service and quality of service of legal tools, and what's the quality of this sort of hybrid setup. We're lucky enough to have with us two specialists, David Restrepo and Greg Lukovic. I'm not sure if I can introduce them to you because one of them works at the University of Brussels and one in HEC Paris. They're both incredibly talented individuals. They have a huge amount of expertise, and we're delighted to be able to welcome with us here today. So let me give them the floor so they can raise all the necessary issues about these different questions that we're wondering about. Perhaps David will be speaking first. So David, you have the floor. Thank you very much indeed. Thank you, Bruno. Thank you to our organisers. Now, there are a number of people who put on headphones, and I was going to speak in English, but I think I'll stick to French. Now, thank you very much indeed. And I'm with Gregory Likovic, and I've been working with Gregory since 2008. And someone told me earlier, well, don't you ever disagree? Well, actually, we do disagree a lot of the time. We've been working via the Smart Law Hub, which is a international European research institute, and we have the University of Brussels, where Gregory works. We have the HEC in Paris, and we have the Artificial Intelligence Institute. We have the TUM, the Technical University of Munich, and we have the University of Copenhagen, with 4 interdisciplinary teams, which comprise both lawyers and engineers, and they work together on several different projects. And perhaps I could explain to you in a short space of time. Someone was talking about this Anglo-Saxon culture and the challenges we have in Europe. Well, we have specific challenges with regard to developing technologies in law. It's the difficulty of developing these tools and scaling them. Why scaling them? Well, because we have so many different countries, so many different languages and legal systems. So when we started working on the different models that exist, and I mentioned this, we started in 2014 with this group, HEC Polytechnic. We tried to look at what was happening in the UK. And unfortunately, we didn't manage to do this. But even when it came to scaling this, it was very difficult because you have to move from a system with several languages in the centre of Europe. We have a very different system in Europe as a result of the market legislation, because in terms of the several different legal systems that exist, which makes it all the more difficult to develop tools or give thought to developing tools from a technological point of view. So we have this group here, the Smart Law Hub, which aims to work on these different tasks and challenges. We're trying to work on a multi-language, multi-court system, so that within some courts we can introduce a model in, for instance, in Belgium, where there's not much data, where, from what I can gather, there'll be a lot less based on the previous panel, but as a result of the generosity of the French Court of Cassation, who I've cooperated with on a number of occasions, and other courts, it will be possible to put this data at the disposal of researchers and to make progress. And so with this project, what we want to do is to create models for other courts where there's not much data, and based on the commonality of civil law. So it's quite a large-scale project. We're at the very beginning of the process only. I'm going to talk to you about... Let me just check. Okay, I'm going to talk to you about changes in terms of competencies. And let me start with something that's, say, target for technology that is not mature. We mentioned this morning, I work for the HEC in Paris. And for those that don't know me, don't know us, we'd work a lot in the private sphere. Not necessarily McKinsey, but to McKinsey, there was a report that was published in 2017 which concerned several different companies in the world, and they were told you shouldn't invest all that much in natural language because it's a technology which will not be mature until 2050, and the text generation won't be mature until 2060. So in 2023, sorry, they revised their prediction, said, sorry, we didn't mean in 2050, we meant 2024, and we didn't mean 2060, we meant 2025. So what's happening now, this is my view in any case, and a view shared by lots of other people, I think, although this is my personal view in any case, we can't wait for technologies to be mature, to reach maturation, if you like, because we have technologies that are not at the mature stage, but we still have to work with them. This concerns everyone. This concerns businesses. This concerns the public sector. This concerns courts. And it's all about ensuring a project is put onto the market, even though it's not at a mature stage. And this is going to continue because there's a technology race, if you like, among the different businesses. And we'll be continuously forced to work with technologies which are not yet fully matured. That's the first idea, that we can't simply sit and wait for these technologies to have matured, to be safe, to have covered everything, because there will always be unfinished products, if you like. Now, listen to the different speakers today. There's one word I switched to my presentation earlier, and I wanted to talk to you about a managerial type approach. But one thing that struck me, and that often strikes me in fact because I'm a lawyer, when there are legal discussions, that there's a complete lack of data, total lack of data. There's nothing on data. And when I say data, I mean, for instance, let's come back to the discussion from earlier, which was fascinating, on the rule of law. Is there data that shows that if you don't publish data, this is better for the rule of law? Can someone tell me how you can keep data outside the public domain, how this can help the equality of arms? Because we're asked for data, but in Europe there's a huge lack of data. We don't have data even for the impact of artificial intelligence. We have very little data. There was a major investigation, 35 respondents for small and medium-sized enterprises, so it's really not very much. So there's almost a sleepwalking that's going on with regard to the impact of the artificial intelligence in the legal field. So there's a huge amount of very serious trends with regard to the impact of artificial intelligence. And I wanted to share 3 studies with you that we've been looking at within our team, so we can give thought together on these 3 terms that are used a lot in our disciplines. This comes back to the 1980s. It's nothing new. There's a reference here, in fact, and it's what's known as upskilling, de-skilling, and reskilling. Now, the idea here is that, without going into any detailed discussions about this, but do we need to ensure there's an upskilling of the legal profession? Do we need to develop additional skills and competencies? This could be cross-skilling with regard to computer science, or is it simply increasing the legal competencies of individuals to be able to face and cope with the arrival of artificial intelligence? Or are we facing the whole phenomenon of de-skilling, because some tasks are being automized, that tasks are disappearing that humans would have done beforehand? Let me give you one example. With regard to contract review, there are a huge number of software programs that can do that in firms. And if you had an internship as a lawyer, then I'm sure you've read thousands of different contracts, different clauses, and this is if you have negotiated a contract and you're 45 years old, you'll certainly remember the sort of clauses you're talking about, whereas we don't have this anymore because junior interns will now read 100 or so contracts rather than thousands of contracts. There's a de-skilling as a result of this process of automation that's going on. What's the impact of this? And then we have the re-skilling side of things. In other words, how can competencies be transformed to reflect this environment? I want to give you 3 examples. I can't give you an answer, but some ideas on this. So when it comes to upskilling, this is related to work that we've carried out. So ANT is a tool that's been developed within our team by Raphael Guerre. He's a research scientist who works with a colleague who's here in the room today. And the aim of this tool is to ensure that conformity managers can properly manage the whole conformity process with regard to artificial intelligence. So this tool will enable the manager, let's see if it works, will enable these conformity managers to note on the basis of labels that are defined by the conformity manager themselves, to note sort of data from several different sources. There could be emails, could be images, could be contracts, and this will enable automatic knowledge graphs to be created, and a whole series of information can be generated to identify if there is an issue of conformity or compliance. And then the conformity team itself will make note of this information, and this will give rise to a result that needs to be taken on board. You may well reply to me. This involves quite some workload. You need to develop tools that work properly. But there is work that's going on behind this, and this work is going to produce this series of results that need to be interpreted by the conformity managers. Here it's important, of course, to reskill, to upskill, that is, with regard to new information and interpreting it. So what we could say here is that here we're dealing with upskilling. So here, let me move to the second point, and it's going to, which relates to de-skilling. We're sort of losing competencies, it's connected to upskilling.
This is a Juribert project. I'm happy that there's somebody here from Juribert who's already spoken at the Council of Europe. So this is a language model. Before GPT existed, a broad language model which was developed to process legal texts in French. The project began in 2016 with the cooperation of the Court of Cassation. It would not have been possible to develop this language without this cooperation. Here, I'd like to show to you the results. This is word to VAC, but this illustrates the difference, as you'll be able to see here, in a vector of 2 legal words, jury and accused, jury and finalist. This is on the model, on the basis of a generalist model. If you move towards a legal model, you're going to come closer to 1. When it comes to similar words, you will be coming closer to legal knowledge on the basis of words because of this fine-tuning carried out on a legal corpus. Here also, with word clusters, you can bring the words closer together. In this model, Juribert, which was trained on 3.6 gigabytes of data, with data from the Court of Cassation in particular, with parameters which range from 60 to 110 million parameters. So compared to ChatGPT, this is a drop in the ocean. But the performance is quite good when it comes to two tasks that the Court of Cassation gave us to do for test purposes. It was a classification of appeal proceedings per section and per subject matter. Now, with this model, which is quite small in terms of parameters, we have a precision rate of 83 compared to other models that use far more parameters, which shows, at least at this stage, that training with specific data is quite good in terms of performance, and you don't need necessarily any GPT to develop this model, which is perfectly suited to a specific task. Now, you might wonder what's happening here. You have a certain degree of automation of a process. If a court were to want to use this on a bigger level with automatic classification, this might give rise to de-skilling in terms of the work at the registry, or even the work of the judges taking part. So the question which arises with de-skilling is, what is it that you need to reskill to go back to the role of the lawyer? What sort of skills are needed for a junior lawyer in a firm who no longer reads all these contracts? How can you make up for this loss of skills? Now, I suggest we look at a few studies here, and I can tell you that there are no legal data. However, in every other area, there are a great number of studies, which is rather worrying. Here there are 3 studies, one in science from the MIT, Harvard, and one of our own at HEC. We worked with consultants and auditors and lawyers. That was the composition of our panel. Now, what did we see? We saw 2 things with the interaction. The average time and the quality of the results increases as assessed by the +1. You might have a member of staff and their partner will assess their work, and you might have an analyst assessed by their line manager. Now, according to the MIT study, in every case the results are better and quicker. And if you look at the skills impacted, the results show that, in fact, the use of LLM is particularly significant. Here you can see you have an experiment. So you have a control group, a control treatment, brainstorming tasks for the control group. The time goes down. Same for drafting. For both of these tasks, people who've used ChatGPT have better performance in terms of time and quality. That's the first study. The other one from Harvard, very interesting, tells us, be careful. Some skills are outside the LLMs. Now, I'm running late on my speaking time, so let me move on to something very interesting. We saw in the MIT study that the persons using LLM had a better performance than those that weren't, even as assessed by their hierarchical superiors. But Harvard says, be careful, some tasks are outside the LLM border. We might think, for example, of the legal tasks which are within the border and those outside the border. The results of this study show that when it comes to the tasks inside, 43% of increase in performance. However, if you look at the tasks outside the border, and I'm sure that you're all curious, but if you're curious enough, you can certainly ask me about this later. For tasks outside the border, the use of LLMs reduces performance. So this raises a simple question. What are the legal tasks outside and inside the LLM capacities? The last study is our own at HEC Paris. We worked with 200 consultants in real life, managers, lawyers and auditors, and we asked 2 two groups to work with and without ChatGPT. To one group, we said, the document has been prepared with ChatGPT. We didn't say anything to the other group, and generally speaking, for both groups, they preferred the results produced with ChatGPT. Over 80% of them did. So you have a member of staff or an analyst doing the work, and this is assessed by the line manager or the partner. In 90% of cases, this work, the work carried out with ChatGPT, was preferred by the line manager, by the +1. Another interesting element in this study, in terms of skills, is the perception of usefulness. That is, the +1s perceiving the use of ChatGPT tend to ask their junior members of staff to disclose the use of it. Those who are very competent and have concerns linked to confidentiality prefer to recommend to their junior staff not to use ChatGPT. So here, it seems that there is a risk linked to confidentiality, but they think that they have enough knowledge to carry out the task. Why am I saying this? If you look at this graph, what type of work did they use ChatGPT for? In blue, you can see about asking for advice. All the persons who used ChatGPT were told that ChatGPT had no knowledge, that it was a predictive system. But even in this situation, there was constant use of it to ask ChatGPT for advice. So it seems, looking at these results, that if the person using ChatGPT has substantial knowledge and that AI presents a risk, they can do without. Substantial knowledge is important. This is one of the teachings of this experiment. One last point. This LLM system works, but the data belonging to the organization has to be ready to be connected to the LLM. This is where you can have added value. This doesn't mean that even if the Belgian judicial system is reluctant to make this data available to the public. Now, if they want to use AI internally, their data has to be ready to be used and connected to other systems, in particular LLMs. I'd like to conclude by saying that clearly there is a transformation in the upskilling. Whether you have public judicial data or not, they have to be treated as data. And you can imagine that generic LLM, fine-tuned to legal data, will be performing sufficiently well that you don't need the judicial data. So it's not a prerequisite. So there's adaptability in the upskilling, understanding, as I was saying earlier on, which legal tasks are within or outside the borders, the LLM borders. That's about upskilling. Now let me move on to reskilling, to make two brief points. First of all, polarization of skills. Research today shows that the LLMs contribute to equalizing skills and substituting work. What do we mean by that? Well, those who are less competent are going to be pushed up to the level of the more competent, even if those who are competent are much further away. But that's what we call equalization of skills. And then secondly, the benefits of AI. There aren't enough studies today to understand how you can create a benefit in terms of collective work with AI. More specifically, an employee working ChatGPT will need less time. Their result might be better, but they might not disclose that they've used AI. They're going to keep the benefit of the use of AI for themselves. If everybody were to do that, for example, at the Court of Cassation, how can you transfer these individual benefits to collective benefits? That is the benefit for the whole court. Now, with the use of AI and generative AI in particular, the benefits remain individual, but we have to understand within the legal system how it's possible to pass on those benefits to the whole organization. Thank you very much, David, for this presentation. Thank you for your conclusion. We've talked about sleepwalking, we've talked about perception. I think we have a specialist of perception and smart law with us today. Gregory, over to you. Microphone. There's no microphone. The interpreter can't hear.
Merci beaucoup. Voilà. Merci beaucoup.
Yes, thank you very much. Thank you for this invitation. We've been asked to look at the future law professionals. Now, my subject will be whether law professionals will still be lawyers, and I wanted to suggest a number of contributions. First of all, legal professionals, is everything okay? Secondly, digitalization, a small hitch here or a small hiccup. And third, conclusion, are new professionals lawyers? Now, why do I want to address this? People often tend to talk about digitalization and these developments as tools. People say there are new tools, they need to be used, it's very good, we're going to have augmented lawyers and notaries and cyber notaries. And I think it's something slightly different that's at play. And I wanted to say a few things about law professionals. If you look at the situation, it all seems to be fine. This is CEPEJ data, averages for the EU member states. If you take a ratio of law professionals per 100,000 inhabitants, everything's comfortable, everything is very stable. We have the same number of lawyers, approximately the same number of judges, prosecutors, notaries, etc. So there's no particular crisis in law professionals. If you look at the market for these services, difficult to assess. We have online figures. Can we trust in those? Anyway, there is an evolution of the market which is approximately in line with inflation, so that's okay. Now, this is the data I found in the Observatory for Lawyers in Belgium. In Belgium, the lawyers' turnover is pretty stable and in keeping with inflation, but there is something else happening on the other side, and this is one measure. There's an increase in the complexity of law and in normative production. So this is about EU law, but I'm sure that we could find similar data for other countries. There are more and more laws and rules. They're more and more complex, and they concern more and more different areas. Now, if you have that additional knowledge, you might say, well, there's an increase in the mass of legal work, but it's not reflected in the number of lawyers or in the amount of turnover. So what is happening to all this extra work that should go to law professionals? Have they become more productive? This is a question that can also arise. Now, do law professionals learn new technologies to be more quick? Not necessarily. This is data for the Brussels Bar Association, but I've looked at the situation in France. It's pretty much the same thing. Most of the professionals don't earn that much money. Some of them really struggle. So do they have means enough to invest? No, they don't. They can't afford to invest. They're pleased enough if they can pay themselves a proper salary every month. Because the law market, if you look at it in detail, well, If you look at the global distribution of income for the Brussels Bar Association, you draw up a Lorentz curve. 20% of lawyers share 60% of the overall income. So most lawyers can't afford to invest. And even if you look at the bigger entities in this market, their margins are very limited. And their practice is that they distribute benefits and profits without investing. So no investment. And in this context, there is a major problem, a problem in terms of access to justice, which has been commented on many occasions. And from the point of view of some stakeholders, they want to come in and offer solutions to those who need the law but can't afford it. This issue of cost, and I'm still talking about lawyers here, means that today the Commission has said that it would really want a reform of the profession. They don't want to reserve so many activities to lawyers who can't carry them out, and if they don't, the Commission said we'll have to look at the advantages of harmonized standards for services. That is, that some of the activities entrusted to lawyers should be taken away from their reserved remit and entrusted to other actors. Now, to take another category, legal departments in companies don't seem to be doing that well because they simply can't keep up. They can't keep up. They don't have enough resources, enough talent, and they can't really face a huge quantity of obligations incumbent on them. And then the compliance departments that are playing a very important role today, well, in this area, lawyers are directly in competition with other stakeholders. For example, people in management, on the one hand, that feel that they're more in a position to provide a service, because it's all very well to be aware of legal rules, but you have to be able to apply them, and lawyers are not terribly cognizant and conversant with business affairs in companies. And then compliance is not a very good area for lawyers. Why? Because what is it that lawyers are doing today? They have to apply a general rule to a specific case. If you do this, you'll never be able to carry out the compliance duties in companies. So you need IT and technology to do this sort of job. So this is what I wanted to say. So the new law professionals are not necessarily there. And when new stakeholders appear, they tend to come from outside of the legal professions. Nevertheless, there is a little problem here, a little hiccup. So you might say, we're going to provide new tools and we'll have augmented professions such as lawyers. Well, that's not really been the case, except perhaps for notaries. The problem is that digitization is not just a tool, it's about a vision of the world. And the digital approach is a certain vision of the world, which says there's only two things in the world, data and data processing. Whatever it is you have, you can give it to an IT specialist and say, this is the entry data, that's the processing, that's the exit data. It doesn't matter what you're talking about. It's a vision of the world.
Let's take the example of finances. Well, it's quite straightforward. Beforehand, we had specialists, so gentlemen traders, if you like, and they used a whole plethora of information to try and make judgments as to how investments should be made. They'd read the trackers, they'd read newspapers, journals, but now we have a different version of this, and this is a tech trader who doesn't need all these tools, reading the papers. They just simply need a huge amount of data, which will be extracted through data mining. And then, rather than carrying out a fundamental analysis of the market to choose where investment should be made, what I'm going to be doing as a tech trader, I'll be using a model. I'll get the model working and identify through this what should be done. Now, it's not a conceptual view only. It does have an effect on the market. Look here. If you look at the blue curve, the blue plot. This is investment carried out by hedge funds based on a fundamental analysis, so the sort of economic fundamentals, if you like. You can see there's a drop, and look at the other cases. This relates to investment that's made based on a quantitative analysis. So the professional who will sort of look very carefully at the investment and will take on board all parameters has been replaced by a quantitative analysis, and that has different consequences, and investors seem to be okay with that. Now, moving to the law side of things, well, it's all about a mindset. When anything can be dealt with three categories, through people, things, and legal operations and obligations. So we'll regulate data processing, and we'll be deciding how this is going to happen. And this is similar to what happens with regard to regulations. Lawyers say, well, look to the IT experts, enough's enough, so we're going to regulate data, and let's see what happens. But the issue with this is that bringing these things together is not always in this way. Often the IT specialists, they win out. They say, well, data processing, well, that's one thing, and rules is another thing, and you can't work in this way. And this is what we call the smart law. That's more scientific and mathematic, algorithmic law. And I'll give you 3 examples, and I'll stop. And this smart law is causing the development of a situation in which, rather than regulating behavior, rather than fixing rules on humans, on people, that what we're doing is we're creating rules on infrastructure. And if you want to regulate infrastructure, then you're not creating rules in the same way. And you don't necessarily need to create them in a natural language. One very recent example is the application of generative AI for finance. Now you have the statements made about this saying it's very complicated because we're used to showing an interest in relationships with regards to an individual, with an institution or funds or banks. Things, if you like, that can be clearly distinguished between. But what we're not used to doing, and what makes things more complicated, is that here we're looking at something that's rather horizontal. It's a model that's used by several different players, and where we don't quite know how we should act, especially with traditional means of action that we use, which won't work, even though we know what the risks are with regard to concentration of models. So to try and regulate this, what do we need to do? We need to do something, and I think the way in which it can be done is being described clearly by the Financial Conduct Authority, that lawyers themselves need to think of them as their roles as data processing. And then in 2021, it stated that we're simply accelerating the implementation of our objective to become a regulator. First of all, regulator for data, and then for the digital field. So it's looking at regulating data and data processing. And it's through this that we can then, and this is an article that we drafted along with David, is that we then are in a position to resolve the whole issue of high-frequency trading. Now, high-frequency trading is algorithmic trading carried out every nanosecond, and that creates small stock market crashes every 30 minutes. It was a problem for several years. And what the regulators did, well, they said, how can we do this? We can't wait for there to be crashes in the stock market to act. We need to regulate in advance of this. So how can we do this? Well, the solution that was come up with is similar to what you find in the US and Europe, is that we incorporated into the rules with regard to European Securities and Markets Authorities duties on all algorithmic operators to send their algorithms to a stress test, to subject them to a stress test in a non-connected environment, just to double-check that this algorithm is not going to commit any misuse of the market. Now, what can we do about this? Well, misuse or abuse of the market. An algorithm is subject to stress testing. It doesn't know what a market misuse is. Well, the rule will be translated into a language will be different. And the algorithm then will become an interpretation of the rule. So we have an interpretation of the algorithm through mathematics mathematical models and not through an individual who decided we should do this or that. And this will enable us to take action on scale, because once we define this, then we can act with regard to the technology. We can regulate the infrastructure. We can say, we want you to apply this algorithm and this control algorithm. We don't want it to produce these different effects. Well, you can say, well, this is what the financial markets are. But let's see, and this in Europe, what do we have? We have the DSA, the Digital Services Act, and the Digital Services Act regulates online platforms, among other things. And what does this regulation and act say? Well, it states that large online platforms shall identify and analyze and assess significant systemic risks stemming from the financial use made of their services in Europe. And they look at any negative effects. They exercise their fundamental rights to respect for private and family life, freedom of expression, information, the prohibition of discrimination, and the rights of the child. And all this needs to be incorporated into the technology in question. What does this mean, guaranteeing the freedom of expression? In a technological platform, you're not going to have a team of people that are going to identify and look at every single message. So once again, you need to translate what you want to carry out into a model. And you need to make a choice between so many models of deep learning that will allow you to identify hate speech. And you need to be able to take a decision as a regulator that, all right, 70% of censorship or 30% of censorship or a false positive, this percentage of false positives, this is good, this isn't good, and this is the rules that we want to include. I'm not talking about science fiction. This is what happens now. You may say to me, well, these are the large platforms. Yes, of course. Let's look at the AI Act. That's currently being drafted. What is changing from fundamental view with regard to the AI Act? We're regulating a product in so many different fields. You want this product to comply with a number of different standards. Before, we always wanted to respect health and safety. We want products that, of course, are not harmful for your health and that are safe and secure. But the AI Act adds one further point. We want products that respect health, safety, and fundamental rights. So what will you do with algorithms, with a model that needs to guarantee the protection of fundamental rights? The Commission replies, well, we need technical standards. What will a technical standard do? What it's going to say, we'll respect this standard, we'll measure the level of non-discrimination for these different indicators and these different metrics, and this is what will be used to be the first judge of exactly what is happening in terms of fundamental rights. It's certainly a good thing, I think, if it's going to be this, because what engineers are doing at the moment is to say, with regard to protecting fundamental rights, well, it's just creating an ethics for AI systems. When I hear the word ethics in terms of fundamental rights, I reach for my gun, because it's taking us back decades. So we have different interpretations that are made, and I think we simply need to standardize fundamental rights. So we don't want to standardize ethics. It's a project that we're currently developing at the moment. Rather than basing ourselves on ethics in which we all invent or reinvent what we want to do, let's look at fundamental rights, let's split them, and then let's look at what the different components are. And based on each individual right, we need to ask if there are matrices, if there are standards that exist. If there aren't any, then let's create standards and metrics, because if we don't have them, then we're going to have a system in which the judge will be dealing with 1% of the issues, and the fundamental rights will be concerning engineering ethics. Now, my last point I want to make, and I'll be very brief, what also changes is that up to now, if you want to enter this debate, you need to have a number of skills as a lawyer. It's not similar to the skills that you're being taught at law university at the moment. And it is quite problematic, in particular if you assume that the legal profession has something to offer to this whole field. Now, things don't stop here, because the legislator themselves, of course, needs to use these tools, and doesn't only want to use these tools to carry out case law analysis, but needs to use these tools to change the way in which laws are drafted and conceived. Let me give you one example. There's something we're developing in Brussels. The idea is that the legislator will ask us, can you create a system which will allow us initially to measure the complexity of the rules, that will allow us to identify how we can improve it. So here you can look, for instance, what we're doing. We're going to apply a series of metrics and measures with regard to the draft standard. We'll look at how complex it is. We'll generate graphs, and they'll enable us to visualize how complex the rule is, how much it ties in with other texts and other rules, and then the legislator will be able to make a better informed decision. Then the legislator will ask us to take this one step further, will ask us to carry out simulations so that we can identify what effect the standard will have. In other words, whether we like it or not, we have the system in which when the legislator decides on the standard, and there's several experts on this, they're drafting a text in a natural language, of course, but at the same time, it's going to be giving an IT code to this, which can be possibly executed and run and for testing purposes, and then this will guarantee the continuity between the intention of the legislator and the regulator and the person carrying it out, because the person carrying it out at the moment, well, it's often been carried out with IT systems. If you draft rules with regard to calculating compensation or rules that need to be applied by major businesses, well, they're in any case going to be translating the standard in natural language to an IT language to apply it within their own system. So rather than allowing the rights to interpret it, the code should be immediately implemented. And that is the no longer having lawyers as modems, but it's providing the code for the norm that can be used in IT systems. And this is a movement that's being supported by the European Union. It is planned that all EU legislation will become digital ready, as we say. And you can see the text that's underlined with a view to addressing the gap between policy formulation and its digital implementation. And this is what's behind all this. We want to address the gap. We don't want there to be any ambiguity. We want to create the rule and give the code. And this enables solutions to be easily distributed. And if it works in one country, it can be distributed in other countries as well. It's sort of a plug-and-play solution, if you like. So that's what I had to say. So the new legal professionals, well, should they be lawyers? I think so, yes. But lawyers shouldn't be surprised by the sort of law of Amara. And we don't want to keep talking about the augmented lawyer every 5 years. There's no augmented lawyer. The fear is that they may be replaced by a robot judge or a lawyer. But we tend to underestimate the short-term impact of new technologies and the gradual transformation of whole areas of law is something that, of course, is a concern by digital transformation. Thank you very much for your attention. Okay. I think I'm going to be the cause of a huge sense of frustration because I know that our two speakers have very little time left before they have to leave us, and they've given so much food for thought. We could spend the whole weekend talking about this between all the different issues we're facing and the issues relating to maturity of technology and scaling it, and rounding off with this algorithm and how it can be interpreted. I'm sure you can imagine, therefore, that we have a number of subjects can be used in dissertations or PhDs. You talked about innovation, and from Schumpeter to Solo, there are so many questions that are being put by economists with regard to this, and I'd be inclined to think that some of the problems that you're raising are issues that already exist and have already been analysed and covered. Now, we don't really have time, I'm afraid, to open up discussions to the room because otherwise our speaker's going to miss his train. One or two questions? You have time for that, do you? Oh, okay. In that case, if they're keen to have questions, then if you miss your train, it's not our fault. In that case, I do have one question that I'd like to put. You're talking about education, but throughout today, one recurring question is what can we do to ensure that lawyers can work intelligently with developers and data scientists so that they don't have sort of a complex, lawyers are perhaps becoming less complex about this. I work in a faculty of law, and I think I try to help our students on masters, but I think we still have problems with the undergraduate students as well, explaining all this to them. But what can we do, in your opinion, to ensure that we improve the way in which this cooperation can be conceived of?
In presentations. My question is more to Gregory, I would assume. What would be the place of big data, big law and big corporations in the pictures that you draw? Because I would assume that you mentioned correctly about the investment that is available for an average lawyer, but what would be the situations for big law firms? And how this influences the entire picture, how to include them in the regulation framework?
Okay. Alors, je répondrai.
Well, let me answer your question.
English. The big law, I think even the big law is not, right now, is not able to invest enough to have their own systems. I think that you have a lot of, the big four, for instance, they have a lot more resources. They are more structured and organized as a one Deloitte, one PwC. They also have some kind of influence and lobby in order to have more and more compliance, where they are, in better position than law firms. So that is exactly the point about how can we change the culture of law firms in general so that they have a way to invest money into some kind of development. But that means also that if you do that, you should be able to present yourself not only as a cost function, but that you provide something more. And of course, that's a tricky question, because so far the idea of the professional or the lawyer is that he will help you to understand the law, to understand your rights, to defend your interest, but he's not supposed to provide you with a product or to sell you a service that will increase the amount of money that you make every year. And that is where, it can be quite complex. So regarding regulation, I don't know exactly what you mean by that, because in fact what we do know, we create more and more regulation. But in fact, all these regulations that are trying to regulate let's say the data and data processing, they only means that you will have an additional layer of technology, because it's too big and it's going too fast to do that manually. So the question is really how we make lawyers skilled enough to contribute to projects in order to design softwares for rules implementation. So.
Et très brièvement.
Very briefly, I think Bruno's question is all about carrying out tests. We need to open up the whole field of law to to experiments, to tests. I don't think we should wait until technology has been consolidated or has matured. We mustn't do that because it will be too late. We need to start working with professionals and students, and I think it's a more straightforward path. We need to incorporate experiments with technology. We need to look at what the failures are. We need to build on those failures and learn lessons from them. And we need to work with, of course, other judicial institutes. Thank you. We have to wrap up, I'm afraid, now, so I'm sorry about that. Thank you very much indeed, and see you very soon for the continuation of the conference.
rejoindre vos places pour que nous puissions à nouveau être bien à l'heure, comme depuis le début de cette conférence. Ça fait quand même partie aussi des moyens de lutter contre la fatigue après une journée entière de débat sur des sujets quand même assez importants. Ce matin, nous avons abordé, lors de la première table ronde, certaines questions concernant les modalités de régulation de l'intelligence artificielle. On a pu comprendre que diverses techniques juridiques ou différents types de raisonnement pouvaient s'appliquer. Le Conseil de l'Europe nous a rappelé que son objectif n'était pas de réguler les technologies, mais
So the objective is not to regulate technology, but to secure the protection of human rights and the rule of law. We've also noted, as good legal experts should, that legal instruments can be binding or not binding. You can have an ethical charter, you can have guidelines, or you can have mandatory rules. Our round table seeks to reply to a very ambitious question. Is technological progress a friend of democracy? All of that within 1 hour. And of course, it's a very broad topic. And to provide answers, I'm delighted to welcome Dominique Boulier, Hugues Versini, and Yves Boulier. I will introduce them in a few minutes. What is at stake is to make available to as many as possible a deep understanding of what the potential of these technological tools might be. So we've asked our speakers to look at those aspects, to perhaps elucidate to some extent the structure inherent in our digital tools that have a strong impact on our democracy, the digital challenges that are specific to digitalization, coding in particular. It's quite a challenge for legal practitioners and judicial practitioners. We have to deal with tools that are supposed to help us make decisions, or predictive justice, help us draft legal instruments that have a significant impact on the way we work, on our ethics. And so, of course, we strive to have a better grasp of what the future holds, what biases might be included in such tools. So I'd like to first of all give the floor to Hugues Versini and Dominique Boulier. You're a professor of IT at the Université Libre de Bruxelles, a member of the Royal Academy in Belgium, and you were the director of the AI lab of the university. You have just published a book that is eminently legible, intelligible, on a difficult topic. Are we going to give power to algorithms? Before addressing that issue of the impact and weight of algorithms in our lives, our social and political lives, can you say a few words as to the way they operate, their impact? You say the way they operate is fairly simple, but that's not generally how we perceive them. So please go ahead. I will give you the floor, Mr. Versini. Thank you. Good afternoon to all. Thank you for inviting me to speak. We have to note that indeed IT is not taught in all faculties. In the Faculty of Law, generally only taught to in the engineering department or IT department. And that's really a shame, because I think that the frame of mind of legal experts is quite consistent with the frame of mind you need to understand algorithms fairly simply. You don't necessarily have to be capable of writing algorithms or devising them. I have advocated teaching IT from a very young age, 7 or 8. That is done, in fact, in Scandinavia. They're at the cutting edge, but in some Anglo-Saxon countries, children learn how to code and learn about algorithms at a very early age. In France, it's pretty good, and courses are given in secondary school, so that's not bad, because we actually need to know how to use algorithms and know how to code more than we need, or as much as we need math. So we need to understand what binary means. You know that everything in computer science has to be expressed in ones and zeros. And then Boolean reasoning, that needs to be mastered as well, because that's sort of the very foundation of AI and IT scripts. How do IP addresses, how do internet networks, or how does the internet work? I've been working in the field of AI for the past 40 years, and there have been ups and downs, that's for sure, ebbs and flows. And, well, despite heat waves, sometimes things don't work out the way we would like. There are two visions of AI, the symbolic vision, reasoning, logic, Boolean methodology. And in the 80s and 90s, we were already looking at legal reasoning using algorithms. And we need to keep that in mind, solving problems on the basis of algorithms, using probability, statistics. That's something that humans are not really good at. We are not well equipped when it comes to statistical reasoning, probabilities. Most of us don't really grasp what it's all about. And computers are far more efficient than we are processing figures and statistics, so it's a good thing to rely on them or to use them as tools, even though we try to improve our reasoning skills by letting ourselves be guided by algorithms. And what have been the recent developments? Data processing, machine learning. So the elderly, like me, find this somewhat regrettable, are not huge fans of ChatGPT. Google says it managed to create ChatGPT the day it got rid of all linguists, which is, of course, unfortunate for those professions. But it is true that the tools yield results that are quite surprising, quite awe-inspiring, without syntax, without semantics, without really mastering the underlying principles, but just on the basis of machine learning with so many parameters. Apparently, the amount of energy required is 300, the equivalent of 300 flights between Paris and New York. So there's a huge amount of energy required. And why are we now looking more at machine learning than reasoning and problem solving? My predecessor spoke about false positives, false negatives, machine learning. I think it's really important to have basic knowledge. What is an algorithm? How does an algorithm learn? How do you validate the learning or the training? What does it mean that a software can recognize or predict at a rate of 90%? What does that really mean? How do you deal with the remaining 10 or 20%? Thank you very much. So indeed, the whole issue of probabilities in interpreting principles, we hear this a great deal in the legal field. And the same issues arised when we were delving into DNA, exploring DNA. So what do we do when you have results that are about 90% correct? What do you still have some leeway as a judge to make the ultimate decision? Dominique Boulier, you are a sociologist and a linguist, Professor Emeritus of Sociology at the Paris Institute of Political Studies. You have written a number of significant publications, Digital Sociology, among others, and most recently, Propagation, a New Paradigm for Social Sciences. That came out at the beginning of the year. You've identified various repercussions of digital development, and if I may, I hope I'm not going to give an inaccurate synopsis of your publications, but you have identified various repercussions that are inherent in digital methodology and the permanent uncertainty that you mentioned. I think that's quite an interesting idea. But as to the technological challenges and what is at stake, we're eager to hear what you have to say. as well, every year things change quite radically, so you have to avoid overreacting. What's interesting is to understand how the algorithms really reflect the legal principles and standards. Well, Lawrence Lessig already said code is law. In algorithms, in fact, we provide legal definitions. The architecture defines our priorities. We have to provide for security, ensure security, reliability, selective authorization. Ultimately, we are dealing with different architectures depending on the priorities, the prioritization, and the way in which our overarching principles are incorporated into the algorithms. And we have to be able to unravel the algorithms, understand the underlying logic. And we have to realize that, for example, Meta has nothing to do with Wikipedia. It's not at all a version of Wikipedia. These are two quite different sources of information. There are categories. Algorithms are constantly creating categories and storing information in categories. And we've witnessed these developments that are quite significant, working on expert systems. There was a time when we would include experts in the development process. The categories would be validated on the basis of the real world, but that's no longer the case. They are generated by probabilities. There are correlation tests that are carried out on big data. And that's not quite the same thing, is it? When it comes to, it's no longer very easy to challenge these models. We don't really know who carries out the weighting. Even those who develop the generative AI don't necessarily know exactly how the results have been achieved. So we have these black boxes. It should be always possible to design white boxes, so to speak. There's always a plurality of options. It's always possible to do things differently, and that's important to realize that we're not dealing with a snowball effect that we can't resist. It's always possible to challenge the results or to do things differently, to implement a different approach. And then I also want to highlight another issue. You really want to look at what's at the core of the algorithms, the interface, but in fact the interface is quite important as well. When you look at ChatGPT, this immediate access, you know that there's the vocal version of ChatGPT. And, well, I've worked on interfaces for my whole life, and we say this is the ideal that we aspire to is immediate access, an instantaneous access to information, as well as transparency. But in truth, we just increase the speed at which transactions take place. It's the marketplace's ideal, transactions that are frictionless. And what are we dealing with here? It's a radical change. It makes it possible for the public at large to embrace this technology. What you see is what you get. Anyone can search on the internet, can enter into this dialogue. It doesn't start, not everyone can program, but everyone has access to this kind of software. So, and this has repercussions for the law because you do away with the concept of informed consent, for example, because things are so opaque, increasingly opaque. We spoke a great deal today about trust. Well, yes, we try to carry out some verifications. When you see that there isn't much public trust, you try to adjust. But here what we ask of the general public is just, yes, to trust, to believe in what is offered to them. And when we developed IT, it's true there are things that are quite consistent with legal reasoning. We have to be precise, you have to be explicit. So there was a form of convergence. But now that black boxes have become the rule, it becomes impossible to really explain what is being done. But again, when it comes to AI, there are different methods, different approaches. Some are more intelligible than others, and there should always be a requirement of reproducibility, testability. There should be some oversight mechanisms as well, or oversight protocols that are marketed, and these prerequisites could be incorporated by design at the initial stage. But of course, it's not that simple. It can be quite problematic, but in a way, it could, perhaps the imperative is to slow things down a little bit, despite the fact that we're just flooded with marketing and advertising. So that would perhaps be the lesson, would be to take things a bit more slowly. Many thanks. That's one of the issues that we are going to address. The fact that there are some economic protagonists that are extremely powerful, that are dominant. Is it possible to slow things down when some of these very powerful players want to speed things up? Yves Boulet, you're emeritus professor at the Law Faculty of the University of Namur, director of the Research Center in Information Law and Society. You work hand in hand with you belong to various international bodies researching respect for private life, freedom of information. Now, as to this other challenge, the power imbalance between various economic stakeholders. Who are those stakeholders? What are the economic, commercial models that are at play and that are significant, have significant impact on the development of digital tools? Thank you, Madam Chair. And of course, I'd like to extend my thanks to all of those who organized this fascinating conference, this meeting. At least I found it really fascinating. So you asked me to think a bit about the economic stakes, the stakeholders, or the main players who, to some extent, govern this economy, and perhaps the issues that arise if you look at things through the prism of democracy. Now, you might be surprised, I'm going to refer back to 1971. Herbert Simon, who was awarded the Nobel Prize, he came up with this concept of economy based on tensions, and you'll see how this applies to the internet, the social networks. The basic tenet was that when you were living in an economy when you have too much information, an overabundance of information, the problem that arises is to use this information in a way that will be lucrative. The problem that arises is you have to draw the attention of people. And what does that mean when you're looking at platforms? Well, we are, in fact, dealing with a plethora and overabundance of information. There's just way too much information out there. And so the question is to try to ascertain how platforms like Google, Metix, the GAFI, doesn't matter who you're actually looking at, but social networks and search engines, how do they attract your attention or one's attention? It's not all that difficult to attract people's attention. What you need to do is develop a number of techniques that rely on AI and that prompt people to focus on a certain thing. It's a certain type of business model, and that's one of the real issues that we're have to contend with. Is our economy is characterized by free access to the internet. It's free for users, so you have to find some funding. Where does the money come from? It comes from advertising, so you have to manage to convince advertising agencies that they well, convince them to pay for the advertising. And how do you go about doing that? Well, what you do is simply to convey the right message, the message that will attract the attention of many people, or at least the right people at the right time. Now, how can AI contribute to that? Well, it's not all that difficult. We've developed and continue to develop, thanks to AI, in particular, what we call micro-targeting. What does that mean? Well, on the basis of a certain amount of data that's collected, and that's where platforms play a very useful role. You think of Google and Facebook and Instagram and WhatsApp, and they all work together. Under the auspices of Meta, you bring together all these social networks, and the whole point is to collect massive amounts of data that's done via cookies and identifying the various browsers to collect as much information as possible. Doesn't really matter what the identity of the person is. What's important is to know what that person's tastes are on the basis of probabilities, to know what areas are of interest to a person in quasi-real time bidding, for example. I'm a member of the Belgian Data Protection Authority. We had to deal with a platform for real-time bidding. And what can happen is in 1/10 of a second, the profile of the person that is compiled thanks to this micro-targeting can be matched with advertising, and then on that basis will be sent the right message. So it's not very complicated. You work on what we call the confirmation bias, the fact that everyone likes to receive a message that is in keeping with his or her interests, what he or she likes, and of course a message that will make it possible for that person to then transmit the same message to others, like filtering bubbles and echo chambers.
Parce que mes amis,
I want to share all of this because my friends share my tastes and my feelings. And then you also have a series of tools such as notches or dark patterns, which gradually attempt to manipulate people and to take them where you want to take them, to become acquainted with the message that you want them to see. So information is no longer considered as a value in itself. What has value is what access to information enables, that is, profiting from advertising. So this is the way in which platforms lead a number of people to what? Well, to share to share information, which the more attractive it is, the more it stands out from the general mass of information. They might be rather it might be rather sensationalist, and the more it has these different features, the more it's going to be shared. A scandalous piece of information will circulate on social media 6 times more quickly than information from a traditional medium. So all of this leads to polarization of society. And I like this comment that I heard recently about the future of Internet. And a specialist answered, well, we wanted Internet to exist. We want to develop Internet as an instrument for dialogue, and it has become an instrument of separation, an instrument used by groups that are increasingly extreme. What can you do in the face of the situation? Well, a number of initiatives are taken in Europe in terms of regulation, And this calls into question the economy and of the internet and the fact that so much is free. And that does raise a question: to what extent will citizens tomorrow, you and I, will we agree in the future to pay for services which so far were free of charge? Not self-evident, but let's think about it. What needs to be done? Maybe we need to ban all these techniques that make misleading possible, misleading of citizens. So we might say that thanks to the Digital Market Act, it should no longer be possible to use data from subsidiaries. Facebook should not be able to use data from WhatsApp for micro-targeting. Now, there's the exception of explicit consent, of course, but this is one of the questions which arises. Gregory was referring to Article 36 of the Digital Services Act. In the future, platforms, the 17 platforms which have been identified, which are very large platforms with a real impact on individuals, well, those platforms henceforth will have to submit their own recommendation system, their own algorithms, to an external source of auditing or monitoring. And people at Google have told me, we can't continue like this. You might have seen this in the news. Twitter is, or rather X as it's now called, with Mr. Musk. Musk has said in the future services will no longer be free. Facebook is also looking at the feasibility of remunerating the social medium, and is experimenting with paying services, I think, in Australia. So all of this to say that there might in the future be an improvement of what we see on internet, at least a calling into question of the adverse effects of these systems. Thank you. Microphone, please. The interpreter cannot hear.
Merci beaucoup pour.
Thank you very much for this first approach, Dominique Boulier. You've also analysed the economic relationships quite extensively, and you've in particular analysed the effects of the deployment of 5G. I was following debates on the public health dimension of this deployment, and you were recalling that behind this there was a war between operators and platforms. Yes, indeed, as Yves has just recalled, it's very important, I think, to look at the role of the digital economy in our societies. It's very important because we sometimes tend to think that there's no link, that all of that operates in a sort of vacuum, that the laboratories that come out with these technologies are sort of in a different dimension of existence, which of course is far from true. In actual fact, we're talking about technologies which are embedded in financial capitalism. It's very important. It's not a matter of industry. It's financial industries. Most of the things we're seeing are due to this, more and more. So we need to adapt. There was 5G, the NFT, smart contracts, metaverse, ChatGPT, etc. It's increasingly fast with non-mature technology. Somebody said this earlier on. But that's not a fatality. It's for purely speculative reasons that this is the case. There's no will, there's no appetite to test liability and responsibility, and there's no anticipation on the part of the industry on what might happen. It's only a matter of having a competitive edge over other players and just being more competitive and quicker than them. Some products have been taken off the market, but we have to be aware of the fact that we're in this sort of world where all the announcements that are made, all the technological developments are decided for reasons of attractiveness for investors. Any technological justification is absolutely untrue and dishonest. In this world, the objective is to satisfy the investors' expectations and make sure that their shares are as valuable as possible. It's not a matter of market value. It's a matter of financial value. It's about the role of financial markets. So it's not quite the same thing. And this is why you have to decode these discussions every time. We might want to do it with OpenAI. The situation is rather complicated there, as you might have seen, because it's all a matter of speculative hits and strikes. That's what they do. I'm not even going to mention Musk. All of this functions because of its financial attractiveness. That's the end game, you know. That's the ultimate aim, to attract investors. Coming back to 5G again, that you were mentioning, yes, indeed, you might remember there was practically no discussion about this. It was presented as a linear sort of progress. And, for example, when it comes to 5G, there were at least two frequencies at stake, 3.5 gigahertz and 26 gigahertz, which completely changes the game. But everybody said, oh, it's the same technology. 5G is better than 4G. And it's quicker. So what I mean to say by this is that there's no decision-making space for all of this. Take 5G, and this is also true of AI even more. There's no standard to discuss this, which is not the true for telecoms, for the telecom industry. All the research decisions are taken within a group called 3GPP, a group which brings together manufacturers and developers, and which is international, yes, but it doesn't include states. The states are completely excluded from all of this. They're working on 6G at the moment. The objective, which might save mankind and justifies all these investments, is 6G, is to be able to offer holograms to everyone all over the place, because, of course, it's very frustrating not to be able to use holograms. That's a very fundamental need for humanity at the moment, to be able to use holograms everywhere. You see, that's the problem. All the developers in these groups, they need to come up with uses that will justify their investments. And so they invent situations that are absolutely ridiculous and nobody's interested in them. And then afterwards, you have to market all of this. You have to try and sell this to the public. There are many other subjects where we would need technology, where we would need networks, where we would need IA, but that's not what's at stake here. And typically, there is a link with IA and holograms. You can imagine all the manipulation, all the deep fakes you can make with all of this. And all these counterfeit people we're going to see arriving, just like counterfeit currency. We're going to have counterfeit people. Some researchers have emphasized this, and the need to legislate quickly. There's a huge risk of identities being usurped. There are two concerns here: more presence, more immediateness, more speed, but nothing about safety at all. Safety, nobody gives a damn. It's not a problem. As you can see, there's plenty of hacking going around, plenty of ransomware, plenty of spyware, all sorts of things, but nobody seems to think it's very serious, because that's not the objective. That's not the point. So to conclude about the battle between the operators, why were these operations launched? This brings us back to the debate on the neutrality of Internet, which was mentioned. Well, you might say, well, this is all very well. We're going to defend the neutrality of Internet. Yes, but the neutrality of Internet is also defended by the GAFAM for slightly different reasons. Because in actual fact, if they want to continue to benefit from a considerable advantage, that is, using technologies and networks which are increasingly powerful, they want to do this without paying for the investments. And operators are getting a bit sick of this. I mean, not that they're to feel sorry for or to be pitied, but the telecom operators are losing out a bit. So with 5G, they're seeing a good opportunity for starting to get their frequencies paid for. You've got things like edge computing, which is interesting because we've been told for a long time that cloud computing was the future. Now it's edge computing. It's the other way around. It's the reverse approach. So, you know, as you can see, these strategies change. Difficult to understand how they evolve. And then slicing. So in actual fact, you can allocate the rate you want to each subscriber. So you can charge them for the frequency rate they want. If you're watching your favorite series in the street on your device, you're going to have to pay according to the exact rate you want. So telecom operators are going to be playing a bigger role again. This is something we were never asked about. So there's no decision-making body about this sort of thing. Nothing at all. It's all the industry. It's nothing to do with public authorities. What about optimization? Nobody is telling us why we would want to optimize things all the time. Not how. We're explained how. We're told how we can optimize, but not why we would want to in the first place. And then there's also the energy consumption. There's corporate liability. When I see some of my colleagues using Amazon Mechanical Turk to test what they're doing, they don't seem to have any qualms about this, but it is a problem in terms of social relations and in terms of ethics, at least for researchers. They should at least think about this before doing it, but no, they do it. They use Amazon Mechanical Turk to help them in their work. So there is a possibility here to bring together all the components in the value chain, and there should be an obligation on the part of the regulating authorities or some sort of authority. There isn't really anybody in charge of regulating IA today. Everybody, all the actors should be asked to explain, to put on the table everything they're doing, all the choices they've made. And then we would have a sort of marketing authorization, which would have to meet a number of conditions. Then people might say, oh, but it's going to slow everything down. It might, but at least we can make progress when it comes to safety considerations, which are completely ignored by many of these operators. Thank you very much. As we can see with what you've been discussing, there are consequences to this technological development owing to certain forces which are not always very clear, and there are consequences on our democracies, on our standards, on our ability, on our capacity to regulate. And there isn't really enough expertise at the service of the common good, of the common interest, the general interest. This is a point you make in your last book, I think, Mr. Versini. Well, yes, after this rather bleak picture painted by my two colleagues, I would like briefly to tell you about an adventure which is taking place in Brussels in the Fari Institute that I created with some colleagues, funded by European funds, and it's called IA at the service of the common good. This is what we're trying to do in Brussels. We are pretty unique in the world. We deploy algorithms for better living, so we're addressing things like access to employment, consumption of electricity, consumption of water, transport. So, you know, what we might call common, public commodities for the public good. When we see that with climate change, we're going to have to radically alter our behavior, we know that with algorithms, my colleagues have said this, and GAFAM have often showed this to our extent, we can encourage certain behaviors. There are two types of algorithm. Guiding algorithms, a bit like the GPS. You don't have to use your GPS system, but they are quite practical, or the recommendation algorithms. Algorithms encouraging us, guiding us, but they're not compelling you, they're not locking you in. And then a different category of algorithms, far more debatable, for more dubious, like Parcoursup in France, which is about access to higher education, or algorithms for accessing certain social rights, which are very dubious indeed. And we know that those algorithms have a power to format. Now, they need to be made available for the common good, to manipulate the behavior of individuals. And we can see that when it comes to climate transition, there is a lot we need to do. We need to considerably reduce the way in which we travel. When Jean-Marc Jancovici says that in order to abide by the Paris agreements, you can only fly 4 times in your life. You know, that's quite a major statement, but it's a logical one. How are we going to decide who can take a plane and when, if it's only 4 flights in a lifetime? And it'll all be decided by algorithms.
Donc, il y aura un algorithme.
So we know it's an algorithm that's going to decide on this. How do you decide how to write up the law? How do you draft a law about this type of algorithm which forces you to do something? And we saw at the time of the breakout of the pandemic, it was a most important time when the Institute was set up, first of all, because we were funded by the European Union, and then because we saw an algorithmic invasion, if I dare say. Perhaps we've forgotten it because we have a short-term memory, but there were so many algorithms, tracing algorithms, QR codes in order to go any place. If you wanted to go to an appointment for vaccination, if you wanted to be COVID tested, it was a real COVID craziness. The tracing algorithms, for instance, were the subject of debates. But in Brussels, we tried to do things differently. Tracing algorithms are useful in order to avoid contaminating others, but perhaps not the way Google or Apple do it, because they decided to have Bluetooth all over to be able to trace you. We decided to do things differently. And the same goes for appointments, for vaccination. We rethought these algorithms because the main thing is to have algorithms which don't force you to this point. You need the support of the population. We could see that many populations didn't want anybody to know where they were. We didn't know where the data was going to land. So there should be more transparency. That's what we're trying to do at the Fari Institute. You can go on our website and you'll see what we're doing. 400 researchers. It's a lot of money. It's a lot of work. And what we're working on is improving access to employment, reducing electric consumption, changing your modes of transport from A to B. Try to use sustainable solutions rather than the car sharing apps, bicycle rental apps, recommendations, so they guide you. They don't force you to do anything. There's actually a cursor. Obviously, things are getting more and more complex, and nature is more and more wounded. So perhaps more and more applications will be forcing you rather than just encouraging you to do things. But it's most important to always ensure that the population somehow supports this type of algorithm. And what we're looking for in Brussels is better approval by the population of what we're doing, understanding that nature is in danger. So how do you do that? You have to inform citizens. You have to have debates, citizen debates. That's what we started doing in Brussels. You have to explain the energetic transition, the need to consume less. We have communities of citizens who together decide how they're going to share electricity. Everybody can't reload the car at the same moment. Everybody can't wash their clothes at the same time. It's the population, it's the citizens who choose, not the GAFAs. The GAFAs mustn't be the ones who choose. There are different ways of showing citizens that it's in the common good that you need these algorithms.
Alors,
thank you very much for having insisted.
J'arrive pas à l'éteindre. Les deux boutons, le bouton.
Merci bien.
Thank you very much. You highlighted the role played by citizens as compared to the big 4 or 5. And it's true that we have to find in our representative democracies a role for the elected representatives, for the political powers. Have to find out what the places for the central state, but also regions or municipalities. Mr. Poulet mentioned it this morning, and perhaps we can come back to that. The legal instruments, you already looked into them. What levers do we have in order to support regulation with an added citizen participation? Well, if you let me first come back to what was just said by my neighbor, because I believe he's totally right. The IA solution definitely needs collection negotiation. We need the local approval. Smart cities, smart regions needs to be discussed and amplified. I believe that it's the best level to have a debate with citizens, with the population. I believe that women and men can bring innovation to algorithms, and that's how we can have an innovative artificial intelligence. What type of regulation do we need? I'll take the example of fake news. It's one of the examples I've been following up upon. The European Commission tried, concerning disinformation, attempted self-regulation. Self-regulation with just a little tiny obligation of reporting by those big GAFAMs to the European Commission with a code of practice on disinformation. It was a failure. And then 2 years later, the European Commission said that doesn't work. It's not possible. The information is not symmetrical. We don't have enough information from those big companies, so we have to regulate. That is when the idea of the DSA came up, which is a very tough set of rules, the code of practice on disinformation. And I think that's a way of proving that it's definitely necessary to have public rules. We need a set of rules. If we want to make sure that it's in the interest of the public, that it's for the public good, we need regulation. And what's interesting is that during the summit in England, it was said very clearly it's time for states to understand that it's necessary now to take into account the risks borne by artificial intelligence. What can we say about this regulation? There are quite a few important points. First of all, when you regulate, it can't only be sanctions. Regulations are also there to prevent. So calling upon the companies to say, you're creating a risk for the society. So it's up to you to assess this risk. You have to make a risk assessment. Previously, we questioned the word ethic, but actually I like the word ethic, not because ethic might be opposed to law, but because ethic isn't simply values. Before all, ethic is a type of approach. When you look at ethics, you have a group of people saying this is what is for the public interest and this is what is not good. So when innovating, I believe it's most useful to assess what the potential risks are and to have a common approach, to look at it together. If you look at what's done at the European Parliament, the assessment has to be done with the various stakeholders, with the unions, trade unions, but also representatives of consumers' rights, with the civil organizations, with perhaps the Authority for the Protection of Data and anti-discrimination authorities, with all the stakeholders. And that is crucial. the idea of having upstream an assessment done. The companies themselves have to assess the risk. Whether they use artificial intelligence, whether they produce these applications, they have to assess it. And at the level of the European Commission, there is also a technological assessment with a follow-up on artificial intelligence. And they can also do some preventive work saying what risks there might be, just as in the world of genetics, for instance, or of advertisement. So I think that's most important. And the second thing, which I believe is most important, is the fact that regulation should not have the same impact on everybody, because I believe that there's some very specific risks, and I'll come back to that. So we need an asymmetrical regulation, such as the Digital Services Act. We have platforms with a very strong impact within a society, so those have to be regulated much more strongly. There have to be more binding decisions. And then the approach should be an open approach. Why should it be open? Because AI isn't just a risk for privacy, freedom, mostly data protection, actually. It's also a risk for the freedom of expression and a further risk for discrimination of various categories of society. Last week, for instance, there was a declaration concerning hate speech. Discrimination can't use the same qualifications of racial discrimination, political discrimination, religious opinion discrimination. There are new risks now with artificial intelligence. There are also environmental risks, as was highlighted by my neighbor. Very important risks, major risks, as he recalled. And within the environmental risks, we have these democratic risks. For instance, we see right now that political parties are dying out because of artificial intelligence. Previously, a political party answered many questions in a very consistent way. But what we have now with all these exchanges on social platforms, you have discussions which look at themes and not with a political ideal. And there's nothing consistent. A political party isn't behind it. It's a disaggregation of the political debate. Because there's a rumor in some social network, an excess in the discourse on the social networks, then decisions are made by governments without even having measured the impact of their decision. I believe these are the major points that I wanted to highlight. We should give them some thought. And the problem also with regulating is that whatever happens, you always have to delegate some powers to the stakeholders themselves. When you're combating terrorism, when you're combating violent speech, hate speech, when you're combating pornography, fake information, disinformation, you always have to detect it, see it, find it, and block it. And that's possibly a good point for artificial intelligence. But it always has to be supervised. There always has to be a human double check. And that's something we have to recall. First comes the freedom of expression, which is the possibility of saying things that possibly won't be agreeable to the majority opinion. But it could also be something which is erroneous, which is wrong. That is freedom of expression. So one way or another, we have to make sure that whilst giving the power, some power, there has to be some supervision. You cannot let these big companies do what they like when combating disinformation. There are also other points which are important, such as transparency, which is something I believe is crucial, transparency of sources, and obviously transparency in the functioning. We know that for the while being, it's not really transparent, and it will never be totally transparent, even with machine learning. Obviously, there will always be some points which aren't clear. The European Court of Justice said, actually twice, no possibility of using artificial intelligence to control in criminal cases or to look at telephone data retention to make an analysis, a predictive analysis of crime committing. Those were the main highlights, I believe. Microphone, please. Thank you very much. In order for us to stick to our time, Dominique Boulier, concerning the means and the risks for our democracy, what are the paths that you would like to highlight? When we are wary and scared of regulating, let's not forget what social networks are. We've had 10 years, actually since 2009 when it started. Actually, in 2004, 2005, the technology as such wasn't a problem. It's not the social activity. It's the fact that there are fees that you pay. That's where the problem begins, as Yves was saying. Because the idea is to get attention in order to make money, be it YouTube, Twitter, or Facebook. From 2009, sometimes you have the same players who go from one to the other because it's the same economic model which is used for development. This had considerable consequences, and we closed our eyes on this for a very long time, although it was so obvious, including the risk of monopoly. In 2009, 2010, there were so many different networks, but obviously they say it's not our fault if we have a monopoly, it's the network effect. Yes, but nevertheless, there was an instrumentalization of some of the platforms. And it was also a way for some not to pay taxes. It's only in 2018, with Analytica, that we saw that there was a risk for the political lever, for the decision makers. It's only when they got upset that they said, oh, time to react. We don't care if we're not concerned. But now it's us who are being attacked. So then there was a reaction. But nevertheless, even that reaction took some time. In the United States, they said that they would try to dismantle these big companies, but we've not seen that yet. At any rate, there was a reaction. Then we focalized on the issue of information, fake information, misinformation. But you have to get into the code, into the very principle which make these networks viral. So the real problem is the rhythm. Even a good piece of information will continue being sent out so quickly that it saturates the system, and it's the saturation which is a threat for democracy. To come back to what Yves was saying, the subjects keep changing. It isn't just the subjects that change. It's not just their subjects. It's insults. It's harsh words that have no room in a normal conversation. It's a loss of capacity to debate, which is actually used by some, not just algorithms and platforms. So there are also these additional threats. So let's learn from that. Let's learn the lesson. It's not an artificial intelligence fault, but nevertheless, it's a tool, and we have a real problem. Do we still have progress? Should we be accompanying some technological progress which will lead to democratic progress? No, unfortunately, that hasn't been the case. The last 10 years, we've had a loss of democracy. It's been self-sabotage of an activity. For democracy, you need time, you need an adversarial procedure. That's what you do in law, that's what you do in journalism, that's what you do in science, and that's what you do in front of courts. The adversarial procedure, of course, takes time. On social networks, no time. It's I react, and I react without thinking. Let's learn the lesson from these 10 years of experience. Otherwise, we'll continue complaining or trying to guess what will happen next or just cross our fingers and hope that the platforms will act correctly. But what are we talking about? Or supremacists of technology. That's what some of us say. Actually, I like that term. There's a deliberate libertarian point of view, but the idea is really to put an end to the rule of law from A to Z. It's not just the major orientations of the state which are threatened. It's any regulation of social life. It's a political ideal of putting an end to democracy. There are genuine enemies of democracy, and unfortunately, they're inspired by the web ideology launched in 1996 by Barlow at the time when the web was commercialized. That was after Ron Sessi, when it went to the private commercial sphere. It was the running code and rough consensus. So rough consensus, no decision-making process. We're all equal. Some are more equal than others, of course. And running code, well, during that time, code was still being produced because that's what's going to make the internet world go on. At the time, the world wasn't too commercial. It was more of a community world, which led to Web 2. But this loss of orientation was a genuine catastrophe. Those people don't have any culture of law. They're actually opposed to law, as many have already said. We have to be conscious of the fact that we're also confronted to this type of individual and this type of groups of people, a model and education. And that's not the fault of digitalization. That's the fault of some individuals and groups. Of course, there's Elon Musk and a couple of others, and they're the ones who pull the strings. Then there are others who might look nicer and are less visible, but they're just the same. So we have to be careful of these people too. So what can we do? Of course, there are the financial levers behind that, because that's very interesting for investors. Oh, everything's possible. Let's just go ahead. Let's test. And as to the consequences, well, too bad. We'll just see later. So it's ideal for speculation, for investment, for making lots of money quick. It's not only an absence of regulation, it's an absence of even orientation. What we do have, at least, is diversity, and I'll be concluding with this. There are still possibilities, plural. Although we're under the pressure of these huge companies and, of course, all their financial sponsors, there are still possibilities. We heard from Hugues everything he's undertaking in Brussels, and there are other people who are trying to do that. We still have Wikipedia and other positive uses, very explicit as to how democracy can work. Adversarial procedure, revision, reviewing, collective overview. If you say, state, come and help us, well, no, we're lost. Because the Americans will say, oh, help, the state, those Europeans, they always wanted the state to act on their behalf. At the beginning of the internet, there was a sort of utopia, and we have to come back to that. We have to support those who have a more utopian, positive vision of how to use the internet. Of course, we can come back to the specific regulation of IA as such, but at the very minimum, we should be making sure that the ecosystem remains pluralistic. Because at the present time, we see that pluralism is being squashed with these social networks, and especially with the platforms, and that will be amplified by IA because it's the same people who have the capacity for this system. So what's the role of the state? The state should always ensure that diversity exists, that choice exists, because no choice means no democracy. So the question I'd like to put is how to support citizen ideas, open source, although sometimes it doesn't exist anymore, how to keep things open, how to have an open ecosystem with citizen initiatives in order to have a choice and say, well, no, we're on the wrong path, let's change track. But no, at this present time, everybody says, let's just do what California does. No, let's just do what they don't do. Develop IA, yes, but in the interest of society and developed by communities. And that's only a way of surviving, by innovating.
Merci bien.
Thank you very much indeed. Hugo Versini, do you think this artificial intelligence in augmented format can help us to overcome the enemies of democracy with these uses against democracy and principles? Well, I think we're not going to get anywhere without artificial intelligence. I tend to be optimistic. Now, despite the justified criticisms levelled by Dominique with regard to the monopolistic use of AI, there are players who use these tools for much more beneficial means, and I don't think we'll overcome the climate change crisis and the overcoming of the inequalities in the world and the problems with transport and epidemics. Let me mention this again with regard to the COVID pandemic. At the time, we all had IT means. We'd have been able to develop IT solutions that respected the well-being of each individual. But what was amazing was if you looked in France, what was the reflex? There was McKinsey with hundreds of millions of euros to set up solutions that a young student in their own university halls could have created. And in the end, the system that was used for vaccination appointments was Slim 2000 in any case. So I think we need to have the right reflexes here, in which our public administrations, which needs, of course, be mindful of these things, and we need to use these players. Now, sometimes we just turn to them automatically without thinking. And there was a debate in France about the Bluetooth Google solution that was opted for COVID. There were so many other ways that this could have been dealt with, which have been far more respectful of people. But the reflex of our politicians, the decision makers, was simply to use the main players, GAFA players. Now, we do have the proof that these tools are very important and very powerful, and these are social regulation tools. There's a sort of conflict of standards and policies and laws, and we have algorithms that come into play, and it sort of formats us, if you like. And I'm saying there's something very severe here about this. It's sort of formatting us in a quite negative way, and it can have a prejudicial effect. But I do think laws can format us well, and with algorithms it can become even more dangerous than laws. We've talked a lot about the different codes, and we need to try and draw benefit from this. We need to try and turn this to our advantage and tell ourselves we can use this to help us. We want to respect the challenge of reducing CO2 emissions by however many percent in the next few years. So we don't want there to be global warming for it to increase even further. Then we need to use these tools. We have them. Of course, we have wind power, solar power, but we need to change our behaviour. Now, we know that the GAFA groups can have an impact on behaviour and mindsets, and we need to look at the different tools that there are, and we need to turn them to advantage. We need to use them in a different way to the way in which they've been used up to now. As has been said, of course, it's certainly quite extraordinary if you look at what's happened in the last years. And you look at how all these tools have been used by this sort of monopolistic players who are just obsessed with profitability and cost effectiveness, and they prevented alternative means of being sought. That is the sort of the means that you looked at in the 1970s, 1980s, the means developed by pioneers of the IT field. But they sort of lost their battle. We need to see what we can do now. We can take initiatives such as one that we developed in Brussels. We can perhaps change things. It's quite complicated. There is a lot of opposition, including from the public administration. They don't have the right reflexes that we'd like them to have, that is to use skills from the academic world or from the citizens and local associations. They don't do that. And we need to try and change mindsets, change reflexes, so we may come up with solutions so we can use these tools to our advantage. Thank you. Anyone else take the floor? Yes, I'd just like to round up my comments. We need to develop initiatives, new initiatives, which are much more grassroots initiatives. The second point I think we should make here, and this is to confirm what Nuni was saying, we need to be very careful about. Empollio was saying, please, I encourage you to read this book. Empollio wrote the engineers of chaos. It's all about the strategy of a number of people and what the impact of AI can be. And the third point I think we really need to bear in mind as well is that we should develop not only alternatives, but more positive things. And we need to look at the pluralistic side of the media. And Europe should start thinking about the Media Freedom Act so that the traditional sort of mainstream media can regain its intrinsic value to information and not only focus on access to information. And we need to look at the whole issue of education. That's where everything starts, of course. I think it's an incredibly important aspect. We really need to educate the young people, the young generations. They need to be able to be critical with regard to the information they see. There's good initiatives, but need to be continued. Thank you very much indeed to our three panelists. So a number of issues have been raised, the education and common education, mathematicians, engineers, IT technicians, what can be done to prevention, repression, citizen participation as well, and diversity, promoting diversity, promoting sort of collective efforts. You've given us a few pointers. Thank you ever so much. Before closing and letting you all go, leave the conference room and to continue with your discussions in a nice, more relaxed setting, I'd like to ask Tigran to join us to present the initiative with regard to the results of this contest that happened earlier.
Giving the opportunity to speak about this hackathon that actually took place this last weekend, and in which our colleagues from IRDG also helped to judge it. There were other colleagues from the Cour de Cassation who helped us mentor the teams. So I'd like to thank very much everyone for contributing to this event. The idea for the hackathon was to gather young researchers, students from different countries which take part in the TGENI project and try to give them a challenge to solve, a legal challenge to solve with technology. And yes, the TGENI is a project that the Council of Europe is actually, it's a project on helping member states find solutions for making justice more transparent, and it's been focusing on technology, it's been focusing on the publication of judicial decisions, on questions of anonymization or pseudonymization of judicial decisions, as well as other elements of related to publishing judicial decisions. So there was a series of events and conferences where everyone got to share practices with each other. You can actually read more about this on a little USB stick, which has actually been distributed to all of you in the bags that you received. So you'll see more of what's been done within the TGENI project. So one of the events of the TGENI project was the hackathon that we organized last week in Paris, and the idea was for the teams to come up with a technical or technological solution to automatically index national decisions, and they received a sample of national decisions from one of the countries that takes part in the project. So to automatically index them with human rights keywords, which do not necessarily appear in those decisions themselves, but are rather based on the human rights terminology that is used by the European Court of Human Rights. All solutions were super interesting and demonstrated quite a significant degree of ingenuity and inventiveness. And we had to make a difficult decision of actually choosing the winner. And ultimately, a team from Norway, which also took part in this event and who we have also invited here, was decided by the judges of the competition as the winner of this competition. Their solution used quite an interesting existing AI solution that, apart from actually finding the links between different keywords and concepts, also graphically represented them. But I'm not going to get too deep into that. They will actually have the chance to do that. So I would like to invite to a round of your applause the Norwegian team, which consists of Oliver Rustejaren, Inger Lippelt, Nashida Nurstani, Dan Uehara, and Lawrence Kiefer. Please join us here. They're actually going to do a very short presentation of what their solution was and what they are. And please. I think you can use this one. Take it. Yeah. Come on. It could be easier. Okay. Yeah. Do you want to have access to the mic? No?
Yeah.
Yeah? Oh, that's okay.
Okay.
Oh, I see that this one is working. So yep. This one's on. So this is the one. You can turn this off and turn that on.
Okay.
Push on this one. Okay, that's fine.
Yes, now this one is working. Oh yeah, we see it there. Okay. So, do you want to start? Ready?
Yeah.
Yeah.
Can everyone hear me? Yep. Hello, everyone. We are Team KAS from Norway, which means keep it simple. And today we would like to present our idea for a tool, what we call Mesher. So we're the team, and I'd like to present Lawrence. He was our team leader for the hackathon, who's at the end there. He's a systems engineer, and he's doing first years and masters. There's Oliver. He's a second-year master's student. Nashida, she's a master's of law in her third year. And we've got Inge to my right here, and she's in her second year of her master's. And I'm Dan, I'm a PhD in legal education.
So, yeah. Sorry. When we started to map the problem, we realized quickly, especially from my experience from using law databases from Norway and also the Hudok database, that the tools are quite difficult and somewhat inefficient, especially when if you're not a law professional. So we wanted to create a solution that was user-friendly and which also gave a graphic overview of the connectedness of the keywords and also the articles in the Human Rights Convention.
So we defined the problem area as being how can we make searching for and finding relevant human rights cases easier and present the results in a way that gives better legal overview. But by better, we mean that we show the interconnectedness between the articles of the Human Rights Convention and their relevant cases. We also identified the uses of our tool, and with the hackathon being only 2 days, we mainly focused on judges and other legal professionals, but we also saw that this tool could be used for other legal enthusiasts, including human rights activists and law students, and maybe later on the general public, but this tool would be then anonymized, and they won't get access to all of the cases, but some of it.
Yeah, so the main aims that we had were to make searching through human rights cases more efficient, develop a user-friendly tool, and present relevant usable cases graphically.
We built a graph which consists of the Human Rights Convention at the center and the articles interconnected with the paragraphs and related keywords around it. We then correlated previous judgments with the keywords and connected them inside the graph. This results in a big graph containing the articles, the paragraphs, and the keywords, as well as the judgments with all their relationships to each other. All the user has now to do is to search for keywords, enter a free text, or even put in a whole case document. The user will then be presented with a subgraph where he can explore the neighborhood of the document he was searching for, see other documents, keywords, paragraphs, and the articles which are related. We also have the option to filter through the keywords by using a menu.
Do you disable it? Thank you. So while developing this prototype, we did a lot of testing with various models for artificial intelligence, and we started out using a very general model that was trained on general English data. But what we found out while working on it is that it worked a lot better if we used the specialized large language models. So our results got a lot better, and they will even probably get even better in the future when we fine-tune our models and keep improving the model. Thank you.
Yes, so our final thoughts is that this project can be have a lot of potential. It can be scaled up, and we also need to do a lot of consideration when it comes to GDPR compliance. It was especially coming from Norway. We are really acquainted with GDPR, and we're taught about it a lot during our studies, wherever we study. So that's also a big, not an issue, but it's a big consideration for us. And working together as a team, an interdisciplinary team was it was challenging, but it was also we learned a lot from working together, and we hope that the collaboration is bearing fruits.
Congratulations. Well, thank you to everybody. So, la conférence donc s'achève.
So we're coming to the end of the conference. Many thanks to the interpreters who make it possible for us to speak in our preferred language, and thank you to all the participants.